Ali. Last week I think so, Dr. Guys, need to mention one item 2435 of your lordship monthly list of 9th of June 2020. Negative marking with the marker that examination. After examination, that was condition was looked on. Direction for evidence ready for it. Persons are selected candidates but could not get that. Well, this is appearing. This is appearing in the appearing. Wait for 465. Wait for some. Now it's not possible. And another person will have 26,000 to negative mark that you put upon. I have intervened. It is now your it is state. Wait for some time. Immediate hearing, fixing date of hearing is not possible. But here, madam, the Supreme, in spite of the order of the Supreme Court, that PI is not allowing us to join in the old school, madam, where the 26,000 appointment has been cancelled, but the persons who are working in another school, they are both the issues can wait. It's not a new issue. Salary has been also not being paid to. Well, I am working there. At this present, fixing. So far, this matters you have to wait for something.
Sir, district motion 24 matter on a area pension matter.
Notice
Area pension matter.
When you have retired?
I have retired long.
Area pension have you where?
CPF to
what is serial number? Is it appearing in the list?
No, not in the
reputation of which year?
24.
24. Monthly list of July.
My lord, may I be permitted to mention one HRA matter for distance down? It has.
There is no urgency to wait.
My lord, it is of 2022. My lord.
2022. I don't have determination 2022. I have determination from 2023.
Your Lordship, may I be permitted to mention this assigned matters, wherein a direction was given by Honorable Justice. This is an assigned matter now. Since 2024 April, CID was to submit a report regarding the. Yes, it is appearing in the list 2542 and 2543, Your Lordship. On before 14 days, it was mentioned, Your Lordship had directed my junior to wait for 14 days if it doesn't appear. 42 and 2543. We have filed an intervener application, Your Lordship. These are analogous matters. 9071 and 10541. This is about some malpractices in the selection process of food inspector, Your Lordship. Thereafter, CID investigation was ordered. In both the writ petitions, identical documents have been annexed, and these candidates have been done very well in the examination. They have done very well, and they have no complaints of malpractices in their respective centers. Both the parties had sought adjournment, and the matter is stayed, Your Lordship. They are the interveners, and they want some directions from the Honorable Court. Last order was passed by Your Lordship when both the parties sought adjournment, and it was to be fixed after the autumn vacation, Your Lordship. But it never appeared later on.
What is the urgency?
Urgency is that the interveners want the stay to be vacated, and necessary direction may be passed on the basis of the report submitted by CID. It is more than a year, Your Lordship, when CID was to submit its report. Both the parties are in collusion, and they are trying to stall the entire selection process. Although they have performed very well, and there are no complaints of malpractices in their 9 centers, Your Lordship. So either re-examination may be conducted if malpractices are there. For food inspector, for the post of food inspector, Your Lordship. Subordinate food and supply services.
Now you are working but not getting salary.
No, I am not working. I have appeared in the examination, but the examination process, March 2024, Your Lordship.
There is an interim order.
Yes, stay.
By coordinate.
Yes, Your Lordship. Yes, Your Lordship. Later on, it was assigned before Your Lordship. This may be taken up, Your Lordship. It will
Well, let me fix up a date when assigned matters can be.
Yes, your lord. May I submit this?
Yes.
Deeply obliged, your
And
lordship.
Mr. Mitra and me,
Sir,
a
take-
similar matter, blood. I mentioned this matter relates to second SLST, blood. We want to file our application, blood, and we have sought for blood relaxation. We have sought for relaxation of our age bar, blood.
Second SLST.
Second SLST, blood. 14th is the last date for filing of application. And Mr. Mitra is
Process of selection started, application time is started. Now we have to apply it there.
yes.
That our question enrolled into judicial order. What order said that all the untainted candidates will be eligible for application. But they've amended the rule, which makes some of the unqualified. That's a short point. With all the urgency is this without selection, time for making application has already started.
Yes, but urgency, School Service Commission has issued a notification, recruitment notification. There, everybody can apply. Where is the difficulty?
Difficulty will not, that selection process has been started, which is violative of order of court. The order of court said everybody will have, all untainted candidates will appear. Now they have made a qualification test under which even untainted, tainted candidates can also appear. And they have also made an age qualification difference, which was not there when the 2006.
Authorities has to complete it within certain time.
Yes.
In terms of the order passed by the Supreme Court.
Yes,
Therefore,
that's
better
the
get,
reason why I want
better get a clarification from the Supreme Court instead of approaching this court.
the Supreme
Because
Court.
court cannot intervene in the matter.
Well-
We know that whenever court will intervene, this point is to be considered that within that time specified manner, this conduct in this is conducted.
Within time to
Now,
and I
now
want to
within
apply.
this time, so far the time is concerned, court cannot relax the time as
No,
fixed
no,
by the
no,
order of the
I'm
Supreme
not asking for rejection that I may be remain conclude that the only thing that those are eligible in 2016 and were untainted, their right to apply should not be interfered with. That is the only thing. Only see the order of court and see the amended regulation. If there is violative, injured in judicial power. So, matter be list of family also here and see if it's something to consider.
What is the last date? 14 July.
14 July.
First July.
Okay. Be permitted to mention one matter. My lord, here, Lordship, I am enjoying an interim order. My lord, passed by the coordinate bench during the petition. My lord, that interim order is expiring on the last date of this month. The interim order will be there till the end of June 2025. My lord, this matter may be taken up, my lord. Important, initially, it is an order of the transfer. The point was raised that it's a penal transfer. Your Lordship had dismissed the writ petition. My Lord, an appeal was preferred against that. The Honorable Division Bench directed an appeal to be filed before the board and directed the appeal to be considered in accordance with law. The appeal was considered. My prayer was rejected by the board. Immediately after that, Lordship, a writ petition was filed challenging that. The the Honorable Coordinate Bench held
Primary.
it's primary teacher, head teacher. It's a transfer related to it. The Honorable Coordinate Bench held that the order passed by the board is not inconsistent with the order of directions of the Honorable Division Bench, and thereafter stayed that operation of that order, Lordship, and the interim order is there till 31st or 30th June. So it will be expired on that.
But this court has passed interim order.
No, the
Coordinate bench. has-
coordinate bench during the
bench has
yes,
passed
my lord, yes. Justice, Honorable Justice,
extension. You
for
want-
extension, or I have not filed any extension since I am within the
Within the
time.
period,
Lordship, can it be taken up on Monday?
Then for extension, that is the appeal.
Lordship, I'll give them the notice. 30 তারিখে expire করছে।
30th June.
Lordship, grateful, my lord.
In March, the matter due to appear in the month of April. There was a direction for filing to primary school council and communicated to me matter not appeared, that's why
It's not appearing in the list.
so
When the last order was passed?
order was passed on 17th March, 2020.
This court passed an order.
No, my lord, the coordinate.
What was the direction?
There was a direction, my lord, matter will appear in the monthly list of April, my lord.
Then let it appear in the monthly list of July. Yes.
And there were two motion, my lord, not appeared, my lord, in the
Motion of which year?
my lord, 24. September 24, my lord, it has been filed, my lord, no, not appeared.
Monthly list of July.
Yes, just mention the matter regarding challenging the notification. Doctors have fixed it as first. Instead of first, kindly keep it on. I am appearing on all these matters on behalf of the SSC. First, I will not be here, madam. Kindly keep it on second. I don't have it. Or one day before, I don't have OTP.
First you have difficulty.
But first, I am not here. I have a set-up program before the election commission. Long back.
Who is appearing for the other side?
Mr. Anand,
Yes, but where is his junior so that the information can be
Huh? Huh? I will, yeah, I will inform. I will inform. I will inform Mr. Or if the first matter comes, kindly keep it.
Yes.
That's
Let it appear on first. Then you tell your junior to remind me.
But just keep it on second, only one day. It can be hard one day before I do it. Another
Item number 897. Assistant teacher for the performing service 38 January 2010, but not concerned due to serving qualified 9 years 9 months. Only 3 months that not done.
897. What is the urgency?
Additional pension has not been granted. Only 3 months short of. They are
When the petitioner retired, wait for some time.
Item number 897.
Sorry, 2010 retirement, wait for some time. Yes. So transfer, I am not upgrading any matter. No. For inclusion, monthly of July. Thirtieth June, extension. Content. Hand over the slip, monthly list of July under the heading content. When you have retired?
I retired
70. Wait for some time. Yes. Of which year? 24, 23. Both will appear monthly list of August. Yes.
primary school.
What do you want? Inclusion in the list?
No, no.
Is it appearing in the list?
Yes, it is.
Under at which serial number?
01.
Yes. What is the urgency?
Agency lordship, earlier order, therefore directed the Purulia to arrange for medical examination of the patient.
Transfer matter?
Yes.
Transfer, I am not upgrading any single matter. Yes.
Your lordship.
You have mentioned this matter on number of occasions.
Yes.
I have not allowed your mentioning. Why you are doing
Because
it?
otherwise the plaintiff number 2 for a college going student has to discontinue study.
What is the urgency?
Urgency because the payment ready for payment from the 2011 to
Payment for what?
payment for area due.
Payment for area dues working in a school.
For a widow and his college
Payment for area dues towards what? Pension or salary?
area.
Area,
salary,
pension or salary?
salary.
So petitioner is working.
Yeah, Med service.
Maid servant.
2000
Maid servant, why you are coming before me?
66,000 gross income there.
Maid servant, why you are coming before me? I don't have
Because
determination.
the money is
I am to hear only the matters related to school.
Yes,
The maid servant,
but outstanding dues they are not getting.
but if petitioner is a maid servant, why you are mentioning? I don't have,
Because
I don't have determination to take up maid servant matter.
her husband was a school teacher, madrasa. Pure.
Sorry, no urgency. Yes.
The new motion for inclusion.
New motion of which year?
25.
25. Monthly list of July.
My lord, item number 147 and 1480. This is these candidates are from 26,000 faithful candidates. My lord, they want they're the untainted candidates of those who have lost their jobs, my lord. They want to participate in the upper primary. Now, my lord, the 7th phase counseling is already over. So, your lord,
So everything is over.
no. It is still there. Vacancies are still there. Your lordship has already considered other matters. My lord, similar matters, my lord. My lord,
Let
there's-
me consider matters, then I
no,
will come
1
to
4.
you.
It's not even hard ones.
Sorry, you have participated.
I participated at the final round due to in service up to 2021 last round.
Yes.
Since in service they were not allowed.
Up to which round means have you
Final round.
uploaded your
Yes.
Thereafter your name was not in the list.
No. It was
You did not participate in the interview.
yes. I participated. I
Yes.
was thrown out because I was in service. But in service candidates are already working. That is why, my lord, the last chance, your lordship.
Considered later
My lord,
on.
it
You
will
have
be
lost
no, it will get over, my lord. Upper primary will get over.
My lord, I'm mentioning two matters for inclusion. My lord, it is an assigned matter. Firstly, this matter came up before the Honorable Justice Aniruddha Roy. And on some personal difficulty, his lordship released the matter, and thereafter it has been, both the matter have been assigned to your lordship bench. Your lordship kindly.
assigned matter.
Yes, my
Yes, what is the urgency?
urgency is that both the candidates at the are working under the judgeship of the Jalpaiguri district, and they are not getting the promotional benefit.
Wait for some time. Yes.
Inclusion as new motion, 2024 matters,
24. Monthly list of August. Yes.
It has been already mentioned, Maladiya, was it direction?
File might have not come. What can be done? Requisition has been sent. Our requisition party to the file class.
But in this matter, directed by an order dated 22nd May 2025, it is the admissible pensionary benefit and child benefit. The department is, DI is not releasing the pensionary benefit, but they are correcting the increment, date of increment in the service book. In the order request.
So I have disposed of the matter.
No, it is.
So there is a direction for affidavit.
There is a direction, but they have not filed the affidavit. But they have.
For that I cannot. You take steps. I am not
I have filed
exercising.
an application. I have filed an
When you
application.
let this application appear under the heading application in the monthly combined list of July.
All the methods that cannot be different.
Eight qualified candidate.
Service Commission might not get qualified candidate not get preferred. So my lord, Supreme Court, ultimately Supreme Court might not.
Retribution of which year? No, it's not possible. Sorry. Sorry. It's not possible at this stage. Yes.
2021 on 9th of June, I mentioned you also rejected me for
Why it should come? It will happen. If it is 2025, it will come as per the presentation.
it was initially first time it was heard by Justice Basu, directed to appear in the monthly list of April. Thereafter in May, my lord, I mentioned your lordship directed within June. On 9 June, your lordship directed for inclusion, come after 15 days. Only for inclusion.
All are 2025.
All are 20.
Monthly list of July. Yes. Restoration application, monthly list of July. Application. Monthly list of August. Yes. Will you indicate this? You indicate this and inform my officer. Give a slip. It will appear. These matters will appear under the heading interruption gratuity. Yes.
My lord, I wanted to mention one matter. My lord, this is a new motion matter of 2024. I am praying for inclusion in the list.
Monthly list of August. Yes.
My lord, inclusion, my lord, 2024 matter.
August.
My lord, may I be permitted to mention on matter in the earlier, the last Monday, your lordship stated me to mention this Monday. My lord, I am humbly praying for releasing the matter as your my lord is the diary is occupied.
What for release? Why release?
My lord, the urgency is that I am saying, my lord. The petitioner is suffering from various gynecological disorders. Where the repetition is transfer. Transfer.
When you applied for transfer?
On 17th March 2025. In the earlier occasion also in 16th December 2024 I applied, and after that I made a repetition. This is the second round of litigation because of that judgment of PF.
If I upgrade your matter, then I have to upgrade at least 500 matters.
My lord, this is
I have allowed prayers of everybody.
My lord,
ignoring the prayer of others. How I can upgrade your matter?
My lord, I am praying for releasing this matter. My lord,
Very well. Tomorrow for release.
My lord, may I be
কাগজ দেবেন স্লিপ দেবেন
Serve notice upon other side.
Lord,
Have you served notice upon all the respondents
yes, my lord.
that you have filed the repetition?
Yes, my
Show me the notice.
The epidemic service not with me. Next day I will ask.
Show me your notice first. Otherwise, I will not include it. You have to show it. Because behind the back of the respondents, I will not.
No, my lord, they have appeared. They have appeared in the last.
When you have served upon
the date.
What was the last order passed?
My lord, my lord,
what was that? Then this matter was taken by which court? This matter was taken by which court?
Your court, man.
Then what was the last order passed?
On 4th April 2025.
Yes. What was the order passed?
My lord directed to appear this matter on 9th April 2025.
Why you did not appear at the time of when the matter was called on?
I have appeared.
Then why it was
no other respondent state was appeared, and the headmaster was not appearing that time, and they have made the headmaster made it separate.
Mention the matter with this order tomorrow.
Yeah, man.
Show me the last order. I have passed. It will not appear in the list. Tomorrow I am granting you leave to mention the matter along with your affidavit of service and the last order passed by this. Yes.
Two methods for application. It is appearing in the monthly list at item number 1945 and 21802.
Yes.
It is appearing in the monthly list, my lord, at item number 1945.
Yes, what is the objection?
My lord, I am not getting the DLF certificate. I have cast in 2019, my lord.
Wait for some time, it's not an urgent matter.
Permitted to mention two matters for inclusion, my lord. Transfer matter for inclusion. 2024.
Of which year?
24.
Monthly list of August.
My lord, may I be permitted?
Yes. How many applications?
Only one matter. Substitution application.
Substitution. Monthly list of July application. Why so many? These are not appearing in the list. 24 matters. Monthly list of August.
My permit.
Inclusion, it is at which stage? Motion or hearing? Motion of which year? 2025. So then it has must have come before me as per presentation form. So what was the order passed?
Your lordship has directed the DI to actually the petitioner's husband was a headmaster of the school.
I don't want to know the story of this matter. Since he have filed the petition in 2025,
no, the main petition was filed on 2024, your lordship.
Yes, when in which month? In which month?
In the month of November.
Then it has come as per presentation form. So when it was heard by this court, what was the order passed by this?
Your lordship passed an order on January last week, and your lordship has ordered the DI to divide the pension between his two wives.
So then I have passed an order. Why you are mentioning this matter then?
The petitioner is not the DI. It's a contempt matter, your lordship.
Who is leading you? Who is leading you in this matter? I know who is leading you. Miss Rai is leading you. Yes, tell her to mention this matter. instead of wasting court's time. First, try to know how to mention the matter and then mention, please. Yes.
My lord, may I be permitted to mention one contempt?
Tell her to mention on next Monday.
My lord, may I be permitted
We'll
to
repeat out everything.
one contempt application for inclusion?
Yes.
My lord, one contempt application for inclusion. My lord.
Contempt month list of July. Yes.
May I permit to mention before your lordship, non-prosecution lordship.
Non-prosecution with leave to file fresh or without leave.
Oh, without leave, just to withdraw. Just to withdraw.
It is appearing in the list.
Yes, yes, appearing in the list. Wait, one is appearing in the list. Simply to withdraw. If they don't want to proceed, I've got the instruction also.
Month, 25th June.
Lordship, may I permitted to mention on matter for upgradation in this country listed in item number 835 of the monthly list. The matter pertains to non-payment of interest on the gratuity and pensionary benefits. The petitioner has earlier filed interest on pensionary and gratuity benefits. The
You are getting pension or interest wait for some time. Try to appreciate my predicament also. Don't please mention blindly. If it is truly urgent, then mention. See, the pensioner is getting pension every month only for interest. Wait for some time.
Lordship, the
Next.
Unmarried daughter's pension for inclusion in the list.
Inclusion of which year?
2020.
my lord.
23 month list of August.
So mentioning, your lordship mentioned for upgradation in the daily list, item number 906 of monthly list. So the matter relates to accord recognition to the petitioner as an unaided madrasa Shikshak.
No, it doesn't matter.
My lord, may I permit to mention one matter for correction?
2023 madam, earlier occasion.
2023 madam.
Yes, madam. Review application filed after the order of dismissal of the writ petition on bail. Thereafter review allowed and the writ petition it was certified, madam. Now there was a direction to place the application before the appropriate date.
Petition of which year?
2023, madam. Sir,
Month list of August.
madam.
Under the heading motion.
7709 of 2025, my lord. My lord, the matter is, my lord, appearing in the monthly list as item number 934, my lord. My lord, it appeared in April, my lord. My question was posted as motion, my lord. My lord, kindly update the matter, my lord. This is a transfer application.
Transfer application, madam. I am not reading any single matter.
My lord, this petition.
Whatever may be, if I read your transfer matters, there are at least 1000 transfer matters before me. And if I start updating transfer matter, I cannot take other matters. Sorry. Yes.
My lord, Mr.
All the list. Yes.
My lord, may I permit to mention one matter for correction? The Mrs. Shabnam Devadan appeared for the state. Her name has not been recorded.
I do not entertain this.
For correction, for correction.
The next step, when again her matter will be taken up, you tell her. No correction is required. Sorry.
Her name has not been recorded.
Yes. Sorry.
Madam, running in the list 2117. Madam, the agency petitioner has been serving in the CBSE private school. Private school, madam.
Is it appearing in the list?
Yes, madam.
So what do you want?
Madam,
What is the urgency?
his son education has been stopped, madam.
Wait for some time. All the list.
My lord, one correction. Name of the petitioner is to be corrected. 19th May order. Order is within my device. No. Petitioner's name is to be
Corrected.
Manoj.
What is the date of order?
19th May 2025. Manoj, it has been Manoj. That is the correction. It has to be MANOJ. My lord, I candidly submit it is my fault. In the petition also, I would require leave also. Neither leave, maybe. Disposed of matter. Disposed of matter because of yes. Very well, ma'am. Very well, ma'am. I candidly submitted because it is my fault. Yes. Unnecessarily, it will take lordship's time.
As per the cost title, then you require to file an application.
Yes, my lord. Yes, my lord. I will do that. I'm grateful to lordship.
Item number 1.
Yes.
Interest on gratuity matter.
same particulars, two repetitions.
My lord, same particulars, no?
Same particular, Bhogidot, Sasmon, these particulars are same, and there are two repetitions, one after another.
Yes,
Why?
First is my lord ROPA 2019 matter, and second repetition is
Ropa 2019 matter.
yes, revised report. And second is my lord on delay for single report. That's why second is single report. Only for single report there is a delay. That's why my lord second repetition.
How this is maintainable? In one go, this prayer, both the prayers can be couched. This is not maintainable. How it is maintainable?
Same
Yes.
another code lordship. Filed two prayer in the
देखिए after repetition now. And at the time of moving this matter, it was not disclosed to me.
No,
my AR code pointed it out while transcribing the order.
it was not here.
So, if your junior does not know the facts, then he should have prayed for time. I never refused prayer for time. Why this could be done? How this could be done? Same repetition or two repetitions, both are running at the same time.
But
How much cost is to be imposed?
Item number one, lordship kindly
Interest amount at the date of 8/12. Please read the prayer of both the repetition. First, read the prayer of 11362 of 2025.
The rate of nature of mandamus, the respondent debits and first the interest 50% per annum, delay payment of the gratuity and amount and ATR pension as per the interest.
That 18% interest.
Real, lordship.
At the rate of 18% interest per annum towards delayed payment of revised gratuity and ADR pension amount as per revised pension.
Ropa.
Now, what is the second prayer? %18 interest per annum from the date of retirement to the date of payment. How this is maintainable?
This is this is single.
How this is maintainable? Please tell me.
Then same prayer looks right to the many courts lordship already I have done that is order has been passed.
Why interest has been paid in both the matters? I couldn't follow. Both the matters relating to interest on pension due to delayed payment.
Yes,
interest on mineral dues. How this is permissible?
First matter lordship.
Have you disclosed pendency of the first repetition in your second repetition? Then how it is maintained? It's a suppression of material fact.
A single PPO lordship petitioner retail.
What is the difference in prayer in both of them?
But item number single PPO lordship petitioner retail on 30th of April 2018 and lordship gratuity amount paid on single PPO 27th of September 2019. This is not a single and my lord item number one.
Then subsequently revised PP was
yes. That's why
yes. Now then how these two petitions are maintained at the same time? One was filed on 19th May and another on 9th. Both are on 19th May. Same date.
Yes.
The abuse of due process of law.
So many court.
How this is permissible? I could understand that after the first pension payment order, you filed one writ petition, and after the revised pension payment order was issued, you filed another petition. That is not the fact. So why two petitions are necessary? Please don't make irrelevant submissions. Issue. Both the repetitions are taken up together. Both the repetitions are taken up together. After they are placed in today's course list as per direction of this. Stop. Next paragraph. On 19 June 2025, writ petition being WPA 11362 of 2025. Heard and an order was passed in open court, disposing of the same writ petition. Stop. While transcribing the order, my court officer found that same petitioner filed two different writ petitions, one being WPA 11362 of 2025, another being WPA 11364 of 2025 on the same date with identical or with similar date. Stop. Next paragraph. Filing of two writ petitions on the same date with similar date appears to be abuse of due process of at the instance of the petition. Had it not been pointed out at a time of transcribing the order dated 19 June 2025, this discrepancy could not be, or this discrepancy might not have been, or might not have come to the knowledge of this. Stop. At the time of moving the writ petition being WPA 11362 of 2025, it was not disclosed that another writ petition with similar prayer being WPA 11364 of 2025 was pending. On same date, that is 19 June 2025, this court passed an order on the writ petition being WPA 11364 of 2025, directing the learned advocate for the petitioner to serve notice upon the learned advocate representing the state respondents, since at the time of hearing of the said petition, state respondents were not represented. Stop. Next paragraph. In view of aforesaid facts and circumstances, court directs the petitioner to deposit cost of ₹5,000 with the legal service authorities, High Court, Calcutta, by 4th July 20. Stop.
I'm enjoying lordship recent board.
Next paragraph. Secretary, Legal Aid Services Authority is directed to file a report before this vote on the next. List the matter under the heading to be mentioned. On 9 July 2025. Next paragraph. Unsigned orders dated 19 June 2025 were both dated 19 June 2025 passed on two writ petitions shall be shall retain on records. Deposit it fast.
I am withdrawing lordship.
No, not at all.
2 to 5.
You have tried to outwit this code.
No, not.
This code will not tolerate this. Yes.
No.
Yes, please call the next one.
Item number 3.
Passports and kindly.
No, not at all. Yes.
Medical ground pending at the end of the commission. Whose temporary suspension of the portal, it could not have been proceeded with. Page 87.
এই ওটা দেখে এইড সার্ভিসেস অথরিটি হাইকোর্ট কালকে আর ওই মনে হয় সেক্রেটারি না চেয়ারম্যান আছে
এইটা
Yes, who is for the state?
All right, sir, but I'm not holding the affidavit of service yet. Being up.
No, court did not direct you to file further affidavit of service. Court directed you to serve notice upon the learned advocate representing the state respondents. Where is that notice?
Yes, I'm not holding it right now. It has been done. I'm
Issue.
not holding it right now. It has not come to me.
At the time of call, learned advocate representing the petitioner has prayed for accommodation to serve notice upon the learned advocate representing the state respondents in terms of the order dated 9 June 2025. Stop. Time to serve notice stands extended by 10 days. Stop. List the matter under the same heading. List the matter under the heading motion in the monthly combined list of July 2025. Next.
Item number 4. No, I'm for the school authority.
Just.
নোংরা কেন হ্যাঁ একই তো এটা হুম
Who is for the school authority? Yes. Why petitioner was not paid salary and not permitted to function as headmaster from October 2010 to 31st March 2025?
But this admitted case of the petitioner that he did not join. Lord, after the
More than 5 years.
order of suspension booked by the Board of Assembly. And Lord, he is admitted.
Petitioner why could not function as headmaster?
Not function. There is no available report that he was Lord attended the school after revocation of the order.
Now he is functioning.
No, Lord, he retired. By this time, like, he retired on attaining the age of superannuation. And now, after retirement, he approached both the school that Lord, I have not allowed to join in the school. Lord, this is after 2011 to 2023. Lord, his Lord, suspension allowance was stopped. Lord, the salary was not paid.
So he was not coming to the school.
Yes, Lord, this is the fact that the Lordship kindly page 100.
More than 5 years.
110. And that's why the DIF school will not refer the matter to the board, the last annexure, which is almost.
Therefore, the version of the school is completely different. He was not coming to school from 2010 to 2015.
My lord, he went there. Here was my lord, he was manhandled in the presence of people, local people by the authorities. So I have annexed the documents. If I was lost with the contractors authorities, DI thrice asked the school authorities to I placed the allow. The Mukti Rit Police that was rejected. Against that, they prepared an appeal before the Honorable Court.
That is in connection with suspension of the petition.
Yes.
Suspension order was proposal for suspension, which was forwarded by the school authority, was disapproved by the board. Now, after that, it was not interfered with by the first single bench and by the division bench. Now, thereafter, why you did not join?
My lord, I went or I could not, I was prevented. I was manhandled in front of the school.
When you have retired?
I retired on 31st March 2020 or 25. Prior to that.
But if this period of 15 years is not regularized, you are not in a position to get.
My lord, the board, my lord, the DI of schools several times.
So when you are prevented, from which date you are prevented after disapproval of suspension?
My lord, from the very next day.
Tell me the date.
My lord, I'm telling my lord, the respondent number, my lord, kindly see.
15 June 2011.
Yes.
Then what legal steps you did take after that?
No, I lost the complaint.
Why you have not approached this court?
That is, I could not, my lord, because you went here, you are prevented, you went there.
Why you did not approach this court? You are coming. Why you are coming after 15 years?
My lord, whenever you went there, you was prevented.
Because if you are not in service for a period of 15 years, from 2010 to 31st of March 2025, how today at this stage court will pass an order granting you, giving direction upon the respondents to pay your pension?
My lord,
because you know the leave rules. If you are out of service for a period of 5 years, it will be deemed that you are not in service.
Deemed resignation. Deemed resignation.
Deemed resignation.
My lord, I several times.
Well, exchange your feelings. Yes. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Grievance of the petitioner is non-payment of a pension in view of superannuation of the petitioner with effect from 31st March 2025 from the post of headmaster. From the post of headmaster of Jalalia High School within bracket HS close bracket district Dokhin Dinajpur district. So, said school authorities represented to aforesaid school authorities represented today who has submitted that from 31st March 2020 who has submitted that from 15 June 2011 till the date of superannuation of the annuation of the petitioner on 31st March 2025, petitioner did not attend the school. So, however, such submission is
opposed is disputed by the learned advocate representing the petitioner, and it is submitted on behalf of the petitioner that he was not permitted to function as teacher as headmaster of the school. Next paragraph. Since petitioner did not work as headmaster of the aforesaid school for a period from 15 June 2011 till 31st March 2025, there is no scope for passing any interim order at this stage. Next paragraph. Issue needs to be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 3 weeks from date. Stop affidavit in reply thereto, if any, be filed by 1 week thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
Great law.
Next.
Item number 5.
Number 485.
I'm for the state, Your Lordship.
We are representing 4 and 5. So why petitioner was not allowed to take admission in class 5?
I am just trying to impress upon Your Lordship. So far as KTPP High School is concerned, this is not a government school. It is under West Bengal Power Development Corporation.
For which the students who are studying in class 4 cannot take admission in a secondary school.
He was there with the primary school, which is under the government. So there was an examination, and this is the
admission
paper. And Lordship, my cutoff marks was 9 out of 40. My Lenafels client got 6.5.
Cutoff marks was 40.
No.
9. Entire examination was of 40 marks, and 9 was the
an admission test.
Admission test was there because it was a private.
This primary school is governed by or it comes under the control of which authority? Primary school.
Primary school, Lordship, it is under Department of Education. And so far as KTPP is concerned, this is run by West Bengal Power Development Corporation. Nothing to do with the government. It is totally under West Bengal Power Development Corporation.
How many seats are there in class 5?
Class 5, 120. Against that,
for which session?
This session. And 606.
2025, 2026.
606 were the applications, and out of which
606 applications were filed for or were submitted for participating in the
exam
in the admission test. Exactly. Now what are the seats? How many seats are there?
120.
120.
Yes.
So all seats are filled up.
To be very candid with your Lordship, 2 lists were published. This is, Lordship, kindly take the trouble.
English
English.
Englishman.
We are concerned with the Bengali medium only. First list and the second list. First list consists of 80 and second list was 20. And thereafter, there are certain seats are being kept, which is totally meant for 4 categories of the words of the employees. One is words of the KTPP employees, those who are, because your Lordship knows the 5 power generating units are there, the transferable services are there, so I have to keep some seats for them. Then government officials, when there is any recommendation from government officials, I have to keep the seats for them.
Thermal power projects. The employees of Kolaghat Thermal Power Project,
yes,
they for them for the words of these employees, seats are reserved. Certain seats, along with the words of government employees.
Government employees, then contract workers, then close proxy within the close proximity.
How many seats are reserved for the under this category?
To be very candid with your lordship, so far as 120 is concerned, my instruction is only 3 are left because of the fact, so far as the third list consisting of these 4 types of contingencies, to cater the 4 types of contingencies, all have been filled up. 3 have been kept for our in-house employees who may be transferred from other power generating units, because I have got 5 power generating.
Excluding 317 seats were for open category candidates.
Yes.
For open category candidates,
Yes.
only 3 seats are reserved.
Only 3 seats are left out. 117 has been filled up.
Filled up by open category or including or a combination of open category as well as wards of employees and officers of
government and the close proximity. And the close proximity that has been taken care of. That has been taken care of. And Lordship, kindly take the trouble. There is
very well you file a short affidavit.
And Lordship, kindly consider this is the letter which was given to my Lenofen's client.
RTI application.
Against the RTI. He was requested in the month of April to get in touch with the school authority. He did not. We are not standing in the way of admission or non-admission. But the thing is,
now if the guardian of the student appears before the KTPP or to the high school or headmaster of the high school, he or she will be permitted to take admission.
Right now, Lordship, it is, to be very candid with your Lordship, now we are in a situation of saturation.
No, seats are lying vacant.
3 are there. We have to keep it for our in-house. 5 power generating units are there. And in the meantime,
where these units are situated? One in Bandel.
One in Kolaghat, second in Bandel, third in Sagardigi, Sautaldi, then Bokreshwar. All are there. So in the meantime, any transferability comes, then I have to cater the words of that employee. I have to, because in the midstream, no school will take care of. That is the whole difficulty.
Yes, you can make the student did not come within the zone of consideration because the marks which was allotted to the students, as it appears, was 6.5, whereas the cutoff mark was 9 out of 40. Now there are 120 seats at present. 3 seats are lying vacant. They are saying that these seats are to be kept vacant.
Employees,
wards of employees, officers of KTPP, if they are on transfer. So how the petitioner will be give a short affidavit, file a short affidavit indicating this, disclosing your difficulties in accommodating the petitioner. I am fixing another date when I will consider this. Learned advocate representing respondent numbers 4 and 5 has submitted that excluding 3 seats in class 5 for the session 2025-2026. It is 2025-26 or 2025 session. Mr. De?
Yes.
24-25 কি বলছেন? 2024-2025. Other
25 only. Session 25.
2025 session. Sentence বলো তো। Other seats are filled up. it is also submitted that also submitted that an admission test was conducted by the school by the authority of Kolaghat Thermal Power Project High School, Purbo Medinipur, where cut-off marks was fixed. Where cut-off marks fixed was 9, whereas petitioner whereas daughter of the petitioner
Son of the
son, whereas petitioner whereas son of the petitioner obtained 6.5 marks. So 6.5 marks as a result whereof petitioner's son could not be permitted to take admission in class 5. Next paragraph.
Class 5.
Respondent class 5. Respondent number 5 is directed to file an affidavit disclosing relevant facts as to why son of the petitioner could not be accommodated in class 5 for the session 2025. Let such affidavit be filed by 10 days from date with an advance copy upon the learned advocate representing the petitioner. Next paragraph lists the matter under the same heading on July 2025.
That cut-off mark 9 was fixed for general candidate. My learner friend's client belongs to the general candidate.
With the marks, cut-off marks fixed was 9 for general category candidates. Documents submitted on behalf of respondent number 4 and 5 are taken on record. Next.
Item number 6.
I am for the respondent number 2, Paschim Bongo Samagro Shiksha Mission.
I am appearing for the state response.
Yes. What is the matter about? Who is for the petitioner? At the time of call. Yes. What instruction you have obtained?
My lord, the petitioner, my lord, this is a third round of litigation. In the second round of litigation, my lord, he moved a writ petition seeking some retirement benefits. He was a para teacher. Now, your lordship directed the state project director to pass a reasoned order, whether he is entitled to receive any lump sum amount or not. Now, my lord, the SPT, my lord, considered the entire issue, and in terms of a notification, my lord, a sum of rupees 1 lakh was given. Now, he retired. She retired, my lord, in 2019. At that point of time, my lord, the prevalent rule was that he is entitled to receive 1 lakh. Now, she is now asking for enhanced, which has been introduced, yes, in 2022 and 2024. Those, my lord, has been given effect to prospectively, not retrospectively. That is why, my lord, that claim is not maintainable. I have, my lord, brought all the circulars, my lord.
At the time of call, accommodation is paid for on behalf of the petitioner on the ground of learned advocate. However, Paschim Bongo Samagro Shiksha Mission is represented and state respondents are represented by learned advocates. Stop. List the matter under the heading motion in the monthly combined list of July 2025. Next.
Item number 7.
Then we have to parity check.
For which selection process?
Yes.
For which selection process, Mr. Bandyopadhyay? 2016 first SLST para teacher. Yes.
Earlier initial teachers working from 2008.
As para teachers.
2008. Then the selection process. Then again the process has been started. Now process has been started. Then we are being asked to appear before for the personality test. Kindly come to
Page 20. Yes.
Notice for the personality test of the successful candidates for the seats reserved for parateachers in first SLS 2020. For upper primary levels, workers transfer is subject to the leave of the Honorable High Court Calcutta. As if the court on its own has granted this.
Notice of personality seats reserved for para teachers. Where from you are reading? Page 281.
Yes.
Yes. What is it? What this notice does say?
The notice for the personality test of the successful candidate for the seats reserved for parateacher of 2020 as issued by the students so it is subject to the leave of the
That I have seen, Mr. Bandyopadhyay. What is the notice of at page 280 says?
280.
Yes. That is 12 March 2024 notice. Yes.
Personal test of the successful candidate for the seats reserved for parateacher first and so shall commence from 2nd April 2022 in the main office of the West Bengal Service Commission. That has been done in our case.
So this is for personality. This is for personality test.
Yeah, successful candidates are called for interview. Then the interview, they were called for the interview. Thereafter, the interview has not taken place as if the High Court has passed an order. Now, I will show you what has happened, whether the High Court on his own passed the order. Now, let kindly come to page 280.
But by subsequent notice dated 13 March 2024, personality test was not stalled. Only clarification at page 21 was that it is as per leave.
Correct. Now let kindly come to page. Let kindly come to page 2. Starts from 296. Personality test was not taken place. Now let kindly come to page 296. Just Miller. Last paragraph. Let us just having page 297 having considered the submissions made on behalf of the party, the court finds filing of the affidavits by the party is necessary to access the got any late affidavits to answer. Petitioner shall be liberty to mention the matter to the fraud experience hearing after the time final experience. After this court did not pass any interim order up to that, then kind it has been submitted by Dr. Patkul and an advocate representing the commission that since in other similar matters submission made on behalf of the commission was recorded, the commission cannot conduct interview in connection with the application process without leave of the court. The same submission shall be made. It is a commission case that they will not hold the interview. How they can say that?
No, Mr. Bandyopadhyay, in group batch matters where also you are appearing, there are certain writ petitioners who have come up with their respective writ petitions praying for chance to participate in the interview in connection with first SLST 2016 upper primary, since they are B.Ed pursuing candidate.
I have no difficulty with if they
Now, excluding them, if today only B.Ed candidates who obtain qualification within the cutoff date are permitted, then their fate is sealed.
no, fate is not still for the timing until the decision is taken by your lordship finally. I mean, I just suggest to lordship. Interview may be taken place. Then thereafter can be stopped.
No, interview is conducted maintaining a ratio, particular ratio, probably 1:1 point with Dr. Patra, 1:1 point 1.4. So if interview of these candidates,
I have become a successful.
no, your eligibility is to be adjudged if other candidates are to be permitted. If they are to be excluded, then you will still emerge.
Kindly appreciate this. This is the one side of the case. Another side of the case is there. 2016 selection process has started. And I will say because of the unsuccessful candidates. Now 2016 again selection process has started. Then again it is stalled. Today we are in 2025. 9 years have been gone.
No, excluding 10% posts which are reserved for para teachers, rest of, yes, that I know, rest of the candidates are permitted.
No,
but in 10%,
that is not the subject matter.
yes, but in
here all restriction is only for the 10%.
now today, if I permit the commission to conduct interview or personal test only for the candidates who obtained B.Ed qualification within the cutoff date, in that event the writ petitions filed by other candidates seeking permission, those who are B.Ed pursuing candidate, their writ petitions will become infractuous.
No infractuous. My lord, kindly excuse me. For my sake, kindly excuse me. Your lordship said, my lord, when we came, when we have started, we are training different. My lord, the course also there. The why for only you, the entire. If you succeed, it has done. And let the if your lordship here decide, I can understand that it was pattern was fixed for some days, but some difficulties matter could not be heard. But in the meantime, if let us proceed, selection is proceeded, interview is proceeded. It will not be any harm of anybody. If they succeed, the entire thing will go now.
No, it's not a case of Mr. Bandyopadhyay, one or two candidates. It's an entire selection process to the extent of 10%. Now, if this suppose there are
something different in Bengal, not from the court side. I am saying, trained in different documents. Kind of see. Every step one has to go to court. Even set aside, Supreme Court has given notification has been made. Stay. I have not got appointment, therefore nobody should get appointment. This has become the approach. I am not saying about the court.
Dog in the manger policy.
No, do not take it there. I am talking about the court, sir. My entire philosophy is now, since I have not got it, stop everything. And kindly appreciate from 2004, 2008, I am working. Now that I can show to your lordship a judgment, I don't need to see their proposition. I am saying, if ultimately, if I succeed, you have to pay me full salary from the 2016. For what reason? Only for the benefits of that person. It cannot be murder.
But also try to appreciate the predicament of this court, because the court is in the midst of hearing the batch matters. Batch matters, where your matter is also there and the other writ petitions matters are there. Now, if I today straightaway permit,
I am hearing your advice, which have been sent to other lawyers. I hope so. You have understood. So, see, I understand every difficulty. I appreciate this court difficulties. But court also kindly appreciate mine. I am asking not much. I am asking another partnership. Let's assume I succeed.
Now, Mr. Bandyopadhyay, if I grant you, if I direct the commission to hold interview of those B.Ed candidates who obtain qualification within the cutoff date, like the petitioners before this court today in connection with this writ petition. Then if ultimately those writ petitions are allowed on merit, then what will happen?
Again, recast.
That's why there is a difficulty to that extent.
Everything is stopped. Or subject to alternatively, I can subject to suggest one thing. If you lot accepts and appreciates. Fix up and is giving a private.
That court is trying within its limited ambit.
Not trying. Your losses are
Tomorrow.
Not sometimes your losses have to do. Not trying. Kind of.
Yes.
Sometimes it has to be done, man.
So very well.
What is remain in my life? Tell me. What more? Getting something parity. I have my life. After all, I have become. Can you see? I have become successful twice. First time I became successful, set aside. I have suffered. Very good. Second time also I have become successful. How many times I have to give Agni Parikha? Sita has given once. Ramchandra has gone for bonobas for 12 years. And we are in a bonobas from 2008 to 2025, 17 years. See about my life also.
But at the same time, the rights of respective candidates are to be considered.
So, kindly do not mind, you are also the person. Because of the unsuccessful candidates, nothing can be stalled.
Yes,
a person who has become unsuccessful for
I get
unsuccessful for
I
twice,
get you, Mr. Bandyopadhyay.
unsuccessful for twice.
But these matters have to be taken up.
I appreciate.
Get you. What is passing to because so far these candidates are concerned, they are complying with the parameters of the recruiting authority.
May I? I will not. May I just? You are not just consider about this. Now, may I just? Kindly, including this matter, give a minute time. I am suggesting, subject to your laws. Tell every council come up with a written argument. Fix up time, 20 minutes, 30 minutes. Let the matter be fixed. The problem is this. These unsuccessful candidates will continue their argument without days together, weeks together, decades together. We are suffering.
Because since you are the candidates who have complied with all the eligibility criteria.
Twice. See, what is nobody will marry me without crossing 40 years, and who will marry me? Who will marry me? Tell me.
Still, you are para teachers.
What para teachers? So what? Age is a factor. Buddha what?
If you want to raise the status of the of the groom, then you have to wait for some time. Otherwise, being para teachers, you can marry.
No. Unless this, teachers are not until it is clear, teachers are not chosen as a candidate now. No market value termination will be.
Well, Mr. Bandyopadhyay, other matters are fixed tomorrow. Tomorrow at 3 p.m. So let this matter appear tomorrow.
Tomorrow I will not be here. Any day, next day, any day. Give me a minute. I will be very short. I rather suggest you give a note there. In the district, sir.
Yes, I get it.
Everyone come up with the written arguments. Finish.
Otherwise, it will never end.
It will never end.
And you are suffering since you are the eligible candidates who have complied with all the eligibility criteria.
All the eligibility criteria from 2016.
Court fee issue. So tomorrow I am posting it,
yes,
and thereafter another date will be fixed after hearing.
Evidence is not required to be filed yet.
Not in this matter. Not in this matter. There are selected candidates we're supporting.
Petitioners petitioners participated in affidavit of service. Last occasion. Petitioners participated in 12th in first regional first state level selection test 2016 within bracket upper primary for 10% posts reserved for para teachers. Stop. Mr. Kullan Bandyopadhyay, learned senior advocate representing the petitioners, submits that petitioners are all possessing B.Ed qualification, and such training qualification was obtained by the petitioners within the cutoff date fixed by the West Bengal Central School Service Commission. Stop. In furtherance thereto, it is also submitted that petitioners are selected candidates for participating in the interview. Stop. Due to pendency of other writ petitions, where petitioners were seeking permission to participate in the interview, considering the fact that those candidates were either pursuing B.Ed qualification after the cutoff date or obtained B.Ed qualification after the cutoff date, comma, present petitioners are suffering. Next paragraph. State West Bengal Central School Service Commission and state respondents are represented by learned advocates. Stop. Next paragraph. Since writ petitions on identical issue are fixed for consideration on 24th June 2025 at 3 p.m.
3 p.m.
Let the present writ petition appear along with those matters tomorrow. Tomorrow, comma, 24th June 2025.
But I will not be there tomorrow, but my junior will be there. Next day, I will. Whenever your lordship fixes for my turn, I will argue.
Very good.
Only a suggestion to your lordship to cut short the. Otherwise, time.
No, I appreciate your agony. Let me see.
You know that a Scots case, 1984 Scots case, very big case. Hearing continued for month after month. In this Scots case, the Supreme Court said, no, this is not allowed. Come up all and make short arguments. If the matter takes so many days, so many parties are there, an unsuccessful candidate will never end their arguments. Develop this. Grateful to them.
Item number 8.
What you are playing for?
To provide the cut-off marks in all the
Cut-off marks for what? In which selection process?
2016 upper primary.
Upper primary 2016 cut-off marks. You are the candidate. What is your locus?
I'm the candidate.
You participated in the selection process for 10% post or for 90% post? Under which category?
No, the letter which with the increase which post.
I am simply asking one thing: whether you have participated for 10% reserve vacancies or for 90% posts in connection with first SLST 2016 upper primary. Yes, Dr. Patro.
My lord, 90%.
90%. Now, what is your grievance now? You participated. Did you upload your credentials in the second phase of selection process, which started from 12.2, Rule 12.2 stage?
petitioner আছে দুজন।
Yes.
চাইছে
একটা মুভমেন্ট কথাটা এটা So you are seeking for direction to participate in the interview. On what basis? These are successful candidates. What about court fee? Have you deposited the court fees of all the petitioners? There are 10 petitioners. Have you deposited the court fee?
I will provide you in the due course of today.
No, first deposit the court fee, then come back. Issue.
Court fees has been deposited, but
In respect of one petitioner,
all the fee, all
issue. Learned advocate representing the petitioner is granted leave to deposit deficit court fees and file documents in support of same on the next date. West Bengal Central School Service Commission and the state respondents are represented by learned advocates. Next paragraph. List the matter under the same heading on 10th July 2023. Affidavit of service filed on behalf of the petitioner is taken on. You file the documents in support of depositing deficit court fee on the next day and obtain instruction appropriately. So what do you want? Dr. Patro, you also obtain instruction.
Yes.
Instruction. Very well. Item number 9.
The petitioner will fortunately untented teacher. Untented teacher, the service has been terminated in the petitioner had participated in the both selection process. 2016 SLST for 1911 and my lord, the upper the petitioner
participated in
upper primary worker registration. This is separate selection. So they both selection process petitioner successfully and in time.
381.
The 1911 selection process is conducted and completed the selection process. That's why they participated and successfully they got the appointment and joined post. So subsequently thereafter call for the counseling process in terms of the notification issued by the government.
Now you are working in working as assistant teacher in connection with after being selected in first SLST 2016 for classes 9 and 10. Now you are also selected in upper primary SLST 2016. Now in connection with your participation in upper primary SLST upper primary 2016, how far you are allowed to participate?
That selection process, what education in terms of the notification issued by the government for creating the superannuation post. That
I am not on whether you are you participated in the in counseling. No.
Because I have in service, that's why I am not participating in selection. But that issue is pending before the Honorable Justice Justice Basu. Passed the interim order by saying the.
But this court has also passed an order in case of in-service candidates. Dr. Patro.
This is not
This is not upper primary.
Wait.
The upper primary process is still ongoing in the sense that the panel is alive and phases of counseling are
7 phases
over. Maybe there will be an 8th or a 9th, we do not know, but the panel is still alive. Work education, the panel expired in 2019. So that was the end of the selection process.
That is in connection with work education?
Yes.
Subject to lordship correction, this panel, the appointment issue in the post of the supernumerary post created by the government. Nobody has till date not getting the appointment. All are the pending before the.
That is the validity of creation of supernumerary posts.
Yes.
Whether in the supernumerary post candidates are to be appointed or supernumerary creation of supernumerary post is valid or invalid. But in your case, you are working as an assistant teacher on being selected in first SLST 2016 for classes 9 and 10. Now, subsequently, you also participated in upper primary as work education teacher. Work education. Now that panel was notified and subsequently panel expired in 2020.
2019.
2019. Now you have lost job after the judgment delivered by the Honorable Supreme Court on 3rd April 2025. Thereafter, you are coming that you should be considered in supernumerary post in consideration of your selection in SLST 2016 upper primary for work education, for the subject of work education. How this is permissible?
I am not that panel expert, but the memo has been issued by the government. And
hey, where is your right?
In that memo,
in that memo, if ultimately that memo survives, then who are to be considered there?
In that memo, my right has been created.
Yes.
Those leftover waitlisted candidates, specifically for them, the supernumerary posts were created. Not for those who were in the panel but did not join, etc. So for them, the panel is over.
I am not.
You did not participate. You did not participate in the interview.
Interview and successfully I have called for counseling.
And the counseling, why you did not appear in the counseling?
But that's why I have the in-service teacher.
Yes.
Yes. Your lordship only.
So therefore, today nothing remains so far you are concerned.
Because in that counseling process, those are got the recommendation.
Where is the counseling notice?
This counseling was on 11th November 2022.
Where is the notice for counseling?
Page 61.
Page
61. 61 and 62. 61 the date of counseling. I called for counseling. My serial number was 89. The understanding saying the panel was expired, but I called for counseling.
So date of counseling was filled on 11 November 2022. Yes. At that point of time, you did not participate since you are working in another school.
But that's what as per 47 paragraph.
Now, when the panel expired, Dr. Patro?
This panel not expired. But they have got appointment till today. In this counseling, all are waiting for appointment. Because
if it is reporting date is 11 November 2022, how panel expired in 2019?
No, panel expired in 2019. Subsequently, supernumerary posts were created in 2022. Then now it appears that then the petitioner was a waitlisted candidate.
Yes.
So
that the point of expiry of the panel will not apply.
No, then I am corrected. Then now the candidate was called, but did not attend the counseling, right?
No, there is a.
Now, if the counseling is not held.
Yes. No, counseling was held. Recommendations all complete. Stay was granted at the appointment stage. All recommendations were given as per this schedule, 2022. Let me take instruction that whether there can be an accommodation or not. That's all. Because our recommendations, the recommendations were all complete. The stay was granted at the appointment stage. Supernumerary posts were created.
Only departure, so far this case is concerned, the petitioner did not appear in the council.
Yes, yes.
But in case of other candidates, they appeared in the counseling. Recommendation could not be made since there is an order of stay.
No, recommendation was also made. Counseling means followed by recommendation. Yes. Then the stay came on appointment. So stay is actually
because
on the
they are to be appointed in supernumerary posts.
Yes. Now here why I'm taking instruction is that the number of supernumerary posts which were created was exactly equal to the number of candidates in the waiting list. So if he did not attend, then that at least one school should be available. That I will check. Let me come back.
Affidavit of service file your affidavit service. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in first SLST, first state level selection test 2016 for classes 9 and 10 and also in first state level selection test 2016 for upper primary level of classes to be appointed as assistant teacher in work education, physical education group. Stop. Petitioner got appointment on being selected in first SLST 2016 for classes 9 and 10, which was got appointed and worked for some time. However, appointment of the petitioner, however, petitioner lost job in terms of the order passed by the Honorable Supreme Court on 3rd April 2025, passed in civil appeal arising out of special leave petition within bracket civil close bracket number 9586 of 2024 within bracket state of West Bengal versus Boishaki Bhattacharya within bracket Chatterjee close bracket and others. So next paragraph, it is also submitted on behalf of the petitioner that petitioner could not participate in counseling on 11th November 2022 since 2022 in connection with first SLST 2016 upper primary for work education and physical education group, since petitioner was working as assistant teacher at the material point of time. Stop. It is also submitted that at present, it is also submitted that selection of candidates from wait list in connection with a selection of candidates from wait list which was prepared in connection with first SLST 2016 upper primary for classes for work education and physical education is not over. Therefore, prayer is made to permit the petitioner to participate in the to participate in counseling process. Next paragraph, Dr. Patro, learned advocate representing West Bengal Central School Service Commission, has prayed for accommodation to obtain instruction whether petitioner can be permitted to obtain instruction whether at this stage petitioner can be permitted to participate in counseling in connection with first SLST 2016 upper primary for work education, physical education group. Next paragraph. List the matter under the same heading for further consideration on July 2025 for 14 July 2025. Okay. Or under the same heading na kore under the heading motion under motion on 14.
না না যা পাবে তাই আসুন রিপোর্ট 14 জুলাই বলেছে রিপোর্ট বানানো
Yes. Item 10.
10. 9.
9 not 10.
Not I am for respondent number 9.
Oh, acha. The petitioner.
You are for the Mr. Dasgupta, you are for
Respondent number 9.
who is
No,
responding?
Kadip Academy, the
School authority.
no, they have not again no grievance against me. They have grievance against Namodaya, my lord. In my
Petitioner number 3 and
the
4.
You are
petitioner,
for? Acha. Yes.
This is regarding admission of a student in class 6. Now, kindly sees at page 35, what are the conditions I have to fulfill? Well, my daughter could not get admission in Navodaya because of this page 35.
Yes, page 35.
Yes, but for rural candidates, B, a candidate seeking admission under the rural quota must have studied in class 3, 4, and 5, completing full academic session from the government-aided, government-recognized schools located in the rural area. However, the candidate should study full academic session, but I am not on that. But the problem is here lies is, well, seeking admission, first two lines, have completed class 3, 4, and 5 full academic session from the government recognized, government aided school. Now, according to Navodaya, the recognition was not there in class 3 and 5, where the Kadib Academy. That is why they have disallowed my admission, my daughter's admission. If your lordship kindly have a look to page 82 once. This is the
Who is the petitioner? Guardian. Father. Page 82.
82. Yes. But this is the Kadip Academy's letter to Navodaya Vidyalaya. Submission of
It is a school run by it is
Privately
affiliated to
managed.
CBSE.
No, privately managed school.
Navodaya
He
Vidyalaya.
is appearing for the.
no, I am not appearing for
Navodaya.
No, Navodaya I am appearing.
It is a affiliated to
It is a government of India school.
CBSE affiliated.
No, it is yes, CBSE affiliate.
Affiliated to CBSE.
if you
Just a minute. What is UDICE? UDISE?
UDICE is a portal introduced by the government of India to keep track of all the school in every state, whether it is
So the
private or
UDICE code was given
no.
by
UDICE,
Kakdeep Academy as it appears from page 82.
no, UDICE code is not the recognition. UDICE code is maintained by the government of India portal. Your lordship will find the UDICE.
So if
code.
I do not study from class 1 to class 4, I cannot take admission in class 5.
No, the rule is, my lordship, kindly come to this. We cannot go beyond the rules. My lord, page 34. 4.4.
Page
34. 4.4. A candidate seeking admission to class.
Page 34.
Yes. A candidate seeking admission to class 6 must have studied and passed these 3 government and 3, 4, and 5 under the
4.6. You are reading 4.6.
4.4.
4.4. Page 33.
Page 34. 33.
Here it is 34. So, my lord, this is.
Now, whether Kakdeep Navodaya is not a recognized school.
No, my lord. I am for Kakdeep Navodaya. It starts from KG to up to class 4, my lord.
Yes.
Though it is under this portal, my lord, for the government officer, but it is not directly recognized because, my lord, your lordship knows for up to class 4, any recognition is not required if I if it is limited to class 4, for 5, 6, 7, 8, recognition is required. For this one, recognition not required, and it's not that I have said everybody that it is a recognized school. I have also not said that. But I have been, for every school to run in West Bengal, I have to get myself enrolled with this portal so that the government state of West Bengal can keep a track how many students are there, how many students are getting admission and everything. And I regularly send report to the sub inspector of school. In that respect, my lord, the government of West Bengal is recognizing that there is a school, but not under any board. It is not recognized under the board of secondary.
What is this? This page 26, Johor Navodaya Vidyalaya Selection Test 2025. Objective and scheme. It's not a statutory provision.
Yes, my lord. Another thing, my lord, your lordship,
statutory provision.
After Right to Education Act 1 to 8, you have to give admission irrespective of.
No, it's not a statutory provision.
Yes, definitely it is.
Come to page 26.
It is the prospectus of JNV. JNV since Johor Navodaya Vidyalaya is a government of India school.
I am saying that what is this page 26 onward is not a statutory provision.
This is the
prospectus.
Prospectus.
Yes.
Yes.
So therefore, suppose a student has not studied in class 1 to 4, he or she will not be able to take admission.
3, 4 and 5. Because
this is contrary to right to education.
Right to education, that is true, but
then where the students will go?
Particularly for Navodaya Vidyalaya, since it is government run and everything is.
Where is the rule? It's a mere prospectus.
Yes.
This is nothing. This is not a statutory provision.
The prospectus clearly speaks that who is eligible and who is not eligible.
2009 rule.
My lordship kindly come to page 93.
What is 2015?
This is regarding.
This page 34.
No. But this is Right to Children Free and Compulsory Education Act.
Yes.
2009, section 15 I am relying. But what just now fell from your lordship. No denial.
Right to children, but this school is run under the government of India, Department of Education. So, if your lordship so desires, Lord, I can produce the statutory provisions as relating to admission.
First of all, this is not a rule. It's not a statutory provision. Second, section 15 of the Right of Children to Free and Compulsory Education Act 2009.
Yes.
What does it say? See section 15.
Section 15. No.
The constitutional right to get education at the primary and upper primary level. How can you deny it by showing a prospectus?
No. I am
whether the candidate has been admitted.
Yes.
But kindly see my admit card once.
No.
But I'm studying in another school.
Yes.
Selection test result. I have
page
6. Page 55 is the admit card, and 56 is the result. I got 91.25 marks.
Page 56.
Yes. Is my marks for which I obtained in this selection test. Yes.
No, he has
total score 91.25. So a candidate who obtained below 91.25 has been permitted to take admission.
But kindly turn to page 58 once. I have been provisionally admitted.
Yes.
In class 6.
Yes.
On 20th of
page 57, you are relying upon. 58.
28th of March 2020.
20. Now they are saying that your admission would be cancelled.
Because the recognition was not there.
Yes,
my previous.
because your lordship kindly come to page
Don't
30.
take such stepmotherly attitude.
No, no,
By
it
the way,
is-
you are
he
a
is-
central government school, and she participated in the selection admission test, got 91.25% marks, and it is not it's a mere prospector, is not a rule. It's not a statutory provision. Not only if it is a rule, it is in teeth.
This is the rule framed by the
provisions of section 15 of
no,
2009.
this rule is framed by the Department of Education, Government of India. So now question
Where is the rule? Show me the rule. Is nothing but a prospectus.
This is a prospectus that is formulated by the Government of India Education Department.
It's not a
That
statutory
who are the
provision.
eligible
It's not. It's an executive director.
I accept your lordship proposition.
Show me that it's a statutory provision.
But it is not a statutory provision. But the thing is, lordship, kindly see page 80.
Compulsory has to be.
Now, whether the petitioner's admission has been cancelled.
Yes, it has been cancelled, and because
I have been denied of getting to attend the classes. That is
From
what
which date?
my lord,
this is a provisional admission. I have not been finally yet.
So now you are attending the classes provisional based on a provisional.
No. Lordship kindly comes to
when the session started.
But the
session already started. Admission is already over. And the question is, lordship kindly see documents page 38.
No, but the provisional admission has been granted.
Yes,
allowed.
That's why page 38. I am saying
58.
No. It is 38 in my page.
জজ সাহেব বলছেন provisional admission.
ঠিক আছে. Documents to be submitted after selection. The parents of the candidate who are provisionally selected for admission will have to submit the following documents at the time of admission and for verification. So
Only this document is that.
My lord, the question is, my lord,
Other documents.
How you can shut the door to a student of class 6 after granting provisional
my
admission?
lord, if we total
It's a central government school.
central government,
It's an educational institution.
unless there is these restrictions.
Be sympathetic to the students.
My lord,
And when there is a specific provision under section 15.
my lord, she is already in a school. She is already studying in a
Permit
school.
her to attend
So
the
it is
school.
not that she is denied the right to education.
Yes.
It is his own representation. Lordship, kindly see. Page 80.
School.
Page 81. Lordship, kindly see. It is not that he is not right to education is only applicable to Navodaya Vidyalaya. Lordship, kindly see.
No, since petitioner's son or daughter has taken admission.
No, he has not taken admission.
Yes,
He has been
provisionally you have allowed. Page
provisionally
58.
selected, not allowed. Provisionally selected subject to furnishing the required documents. Otherwise, she
No,
will.
this is how this. Where is the how this requirement can be considered as sacrosanct in view of there is no statutory provision, and that your stand is in teeth with the in teeth of the provision of section 15 of 2009
The
Act.
total seat is 80. Total number of seats. We are taking admission in class 6 and class 9.
Very well. Total seat is 80.
80. And if this is subject to your lordship's approval, my lord, if this is given, my lord, this is allowed, my lord, there will be a floodgate, because we cannot accommodate unless there is a statutory, unless there is a rule to restrict the candidates, my lord, there will be a floodgate.
No, where is the question of floodgate? Because if you have 80 seats, you conducted admission test.
Yes.
In the admission test, petitioner obtained 91 point. Where is the result of the admission test? You have just shown me. Yes, page 56.
Yes.
Petitioner daughter of the petitioner obtained 91.25 marks.
No, I am not disputing that.
Is it your case that any candidate who obtained all the candidates who were permitted to take admission got higher than 91.25?
It is not the question of higher. Only embargo is that the rule speaks, that the prospectus speaks, that the candidate must undergo study up to 5 in a
So
recognized
therefore, no,
semi
no,
government.
why I am saying this? You are saying that floodgate will open. What floodgate will open?
Because there,
Because
I am not.
it is to the admission test, and admission is to the extent of 90 or 80 seats.
80
Question
seats.
of opening
Well,
floodgate will
after-
not happen.
no.
Will not arise.
It is-
Only question is whether a student of class 5 who are studying in a school which is not recognized by the state government or any government organization,
Yes.
whether he or she can pursue the course or not. If you say that he cannot he or she will not be permitted to pursue the course in class
Maharaj,
6,
in
in that event, that particular student will not be permitted to take admission in any other school.
Only one. No.
So what will happen to that candidate?
In that event, this rule is to give a go by. Otherwise, there will be no rule.
There is no
Anybody and
rule. You
everybody.
are not in a position to show any rule. It's a prospectus.
Yes.
It's an administrative order,
Yes.
which is contrary to provision of section 15.
No, it is true. Lord, if your lordship
Yes.
finds that, that is fine.
57
So now you are attending the school or not?
I'm attending a school,
Yes,
another school.
page 85 in another school. I am
So when the session started?
But the session,
25.
your lordship will have a look to, but see this session. Just a second.
বর্তমানে আমি সরকারি উচ্চ মাধ্যমিক স্কুলে ষষ্ঠ শ্রেণীতে পড়াশোনা করছি।
Oh.
So therefore she has already availed the right.
Already studying in another
Yes.
school.
What can I
That
do?
is
My daughter has been
that is
denied admission. in my-
Where from you are getting this?
my lord, page 85
This court was anxious to find out whether petitioner's daughter would be permitted to attend any other school or not.
Yes.
If you have taken admission in attending other classes in another school, question does not arise.
85
only one
page
This is
85
page 89.
it is 85.
Then the entire exercise is academic.
85 that is his representation, my lord, the fifth or sixth line. কিন্তু মহাশয় এই স্কুলে অনলাইন দেখা যাচ্ছে প্রাথমিক স্কুলের সাথে যার জন্য আমার মেয়েকে ভর্তি নেওয়া হচ্ছে না। বর্তমানে আমার সরকারি উচ্চ মাধ্যমিক স্কুলে ষষ্ঠ শ্রেণীতে পড়াশোনা করে। She is already studying in class 6.
You are studying in another school.
Yes.
Yes.
And a government school.
No, because of the denial on the part of the.
But today, the
Till
student
December,
cannot take admission in the school in mid-session.
Yes.
Absolutely true.
Because session started must be April. Today you are in the month of June. You have already taken admission in another school. So mid-session admission.
Grants me that leave. But only one page I want to show to your lordship. But page 57, kindly have a look.
No, I could exercise the power of an equity court, provided you are not permitted to take admission in other school. In another school, you have taken admission and you are studying there.
Yes.
So therefore, at this stage, it is not necessary.
School, but I have been denied.
Mid-session admission is not required since you are studying in another school, because the criteria or the requirement of section 15 is fulfilled.
That school is West Bengal board school, and its session starts from January to December.
It is also a school.
Absolutely school.
So study there. Yes, sir. Attend the school regularly.
Only one page may I show? Only one page.
Nothing. Yes. Yes.
Thank you. But next
Petitioner
year, if
affidavit
your
of service
lordship
filed on
grant me
behalf
that
of the
leave.
petitioner is taken on record. Next paragraph. Petitioner's daughter participated in the admission test conducted by Navodaya Vidyalaya Samiti, conducted by Navodaya Vidyalaya Samiti for taking admission in class 6 for the session 2025. Stop. Though petitioner, though the student, it is submitted that student obtained 91.25 marks in the admission test, but was granted provisional admission as it appears from a document at page 58 of the writ petition. It is also submitted that due to the norm of the central government relating to taking admission in schools under Ministry of Education, Government of India. কি বললাম সেন্টেন্সটা?
Human Resource Development,
which prescribes
Ministry of Education.
For taking admission in class 5, candidate must have studied and passed classes 3, 4 and 5.
Class 6, my lord.
For taking admission in class 6, বললাম তো?
Yes.
For taking admission in class 6, candidate must have studied and passed classes 3, 4 and 5 from this government aided / recognized school, spending one full academic session in each class, comma, student or the daughter of the petitioner, was not granted permission to take admission in class 6 in class 6 in the class 6 permanently or finally. However, stop. However, it is submitted on behalf of the petitioner. It is also submitted that such norm of Navodaya Vidyalaya Samiti is contrary to the provisions or is contrary to Section 15 of the Right of Children to Free and Compulsory Education Act 2009, which prescribes a child shall be admitted in a school at the commencement of academic year and no child shall be denied admission if such admission is sought subsequent to extended period. Next part. Prayer is made for permitting daughter of the petitioner to take admission in class 6 in Navodaya Vidyalaya Samiti. Next paragraph. Such prayer is opposed by the learned advocate representing Navodaya Vidyalaya Samiti based on norm of the said school relating to admission, and it is also submitted that daughter of the petitioner is presently studying in an higher secondary school, is presently studying in class 6 in higher secondary school, which is a government recognized school. So, in this regard, letter of the in this regard, a letter dated 18 April 2025, which is at page 18th April 2025.
8th April.
8 April 2025, which is at page 85 of the writ petition, is relied upon. Next paragraph. Having considered the respective submissions made on behalf of the parties, it appears, though an attempt has been made on behalf of the petitioner to raise the issue or to raise the issue to question the stand of stand of Navodaya Vidyalaya Samiti in denying admission to the daughter of the petitioner based on norms applicable in the said school relating to admission. In view of the relevant provisions contained in Right of Children to Free and Compulsory Education Act 2009, but in view of admission of the daughter of the petitioner in class 6 in another state government run higher secondary school, issue has become academic. So, since daughter of the petitioner is studying in another school in class 6, in the event at this stage writ petition is allowed, permitting the daughter of the petitioner to take admission in Navodaya Vidyalaya Samiti, that would result in mid-session admission, which will not be conducive to the academic interest of the student. Next paragraph. Hence, writ petition stands disposed of. Urgent xerox certificate.
Provision says till 31st
matter.
of December, but I can do it.
Item number 11.
Yes. Working.
Anyone?
Have you made any representation?
অনেকগুলো ফাইল আছে কিন্তু পোস্ট ফাইল 86
এই শোনো, এইখানে না ফটো করে দেবে, আর বাদ বাকি সব ঠিক আছে। ইয়েস, ডিসপোজড অফ।
And for the state.
Please give your appearance.
Item number 12.
And for the state, my lord.
Same. Working. Working. Whether representation has been made? No representation. শোনো, এই আগেরটা যেটা হলো সেম অর্ডার ওইটাই ফলো করবে fortnightly. Is disposed of, which for the state.
For the service.
Give your evidence.
কাগজের মধ্যে। Item number 13.
আছে
Working or retired? Retired. Representation? No representation.
Amount or deposited? Amount or deposited?
Amount was deposited means? So that is not relevant here. Only your entitlement to get 3% additional increment is to be considered. এই শোনো, এটা ফর্টনাইট হবে আর এখানে পিটিশনার হ্যাজ রিটার্ন ডিসপোজড অফ। নেক্সট
Item number 14 for the state respondent, my lord. The similar prayer has been made, I found, my lord, and the representation is also there at page 69.
So, yes, retired or working? Retired, in service. Representation made? Which page?
Page 69.
69.
The representation is due after 6 years. He was appointed as headmaster in 2019.
Where is the receipt of representation apart from postal slip?
Yes, my dad. UDP, that is.
Only one postal slip is there, dated 10th April 2025.
My lord,
10th of May, the letter was dispatched. Subsequently, my lord, we found that this date, which has been mentioned in the poster, is very mistake. Therefore, in the list of it, we have.
So you have not given authority not even in 1 month time to respond to
It
this.
was a mistake on the poster slip which has been.
So make a refreshed representation. In the month of April, this representation, and month of May, writ petition has been filed. Let it appear in the month of December under the heading motion. শোনো, ওই আগেরটা ধরে করে দেবেন। হ্যাঁ, এটা ফলো করার দরকার নেই, রিপ্রেজেন্টেশনটা কনসিডার করতে বলবো না। হ্যাঁ, নট রিটায়ার্ড হ্যাজ রিটায়ার্ড, ওটা থাকবে না। Disposed of. Make a representation within fortnight and that will be considered by 12 weeks thereafter. Is
Item number 15.
yes, same. Working? No representation. এই আগের একটা অর্ডার দেখি। না রিপ্রেজেন্টেশন না, আর এটা তো বাদ দিতে বললাম, এটা তো ফলো করবে না। আর একটা দেখো 11 দেখি ঠিক আছে, ঠিক আছে, ভেরি ওয়েল, সেম অর্ডার ডিসপোজড অফ। নেক্সট,
Good. 11, item number 11 to 15.
by the where is Mr. Jana? Yes. দিয়ে দাও আমটা।
Good.
Yes, next matter.
Item number 16. Lord, I'm for the petition in this matter. Also, well, she's a cancer patient. She came before your lordship previously. Your lordship directed grant the liberty to file afresh because there was not in prescribed pro forma. Now it has been made. Her medical verification has also been done, and I came to learn that it has been approved. So, my lord, kindly come to lordship's order first.
Medical verification has been done, and the medical report has been provided to you.
Not to me. I came to learn it has been done. Possibly my learned friend has it. My lord, kindly come to page 96, your lordship's order.
medical?
And my lord,
96.
96, your lordship's order. But it was not in prescribed pro forma, so I had to withdraw it. And
yes.
And then, my lord, page 103, I made in prescribed pro forma. School has given
Now the medical verification has been done.
Yes.
So what is the present stage, and what do you want?
Transfer, my lord. She's suffering at a severe stage. of
Transfer.
cancer.
Now, what where the application is lying? Before which authority?
It is possibly she has
Commissioner.
instruction.
Why commissioner? It will be sent to the West Bengal Central School Service Commission. Yes, yes. Give me the.
Her medical has been done. This is the, I think, medical. Lordship,
We have the soft copy right now because I just received
medical has also been done. Yes. It has been found severely. কমিশনে পাঠায়নি তোমরা? না না, কমিশনে পাঠাওনি কেন?
দেখি ওটা দাও। ওটা দাও, একটা
নিচে দিয়ে কপি টু করা আছে কিন্তু। Yes, it has also been sent to the commission.
নম্বরটা আমার লিখে নিন, ওইটা পাঠিয়ে দিন। এটা
এই তো পাঠিয়ে দিয়েছে তো, এই তো।
আরে ওই রিপোর্টটা।
হ্যাঁ, সব শুদ্ধ পাঠিয়েছে তো। এনক্লোজারে দেখো ওই সাইডে।
জানি। 9898
My lord, it has also been sent to the commission. If your lordship kindly take.
Where from you are getting this?
From the your lordship is holding that document. Kindly see at the bottom. Copy
Just
forwarded for information. Copy forwarded for information. So what there?
Page?
No, that your lordship is holding the document. Yes. Lord, kindly see 11th of April 2025. My learned friend.
Just a minute.
9814 P1680 National Service Commission SS। এটা ওই ডকুমেন্ট পাঠিয়ে দিন। এটা আছে, এটা নিয়ে নিলাম। এটা হোয়াটসঅ্যাপ, এটাতে পাঠিয়ে দিন। Yes.
It was forwarded to the chairman, West Bengal Central School.
Yes, yes. ওইটা একটা পাঠিয়ে দিন আমাকে।
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner preferred a writ petition previously being WPA 4790 of 2025, which was dismissed by this court. Video order dated 20 March 2025, and liberty was granted to file afresh on self-same cause of action. Stop. Next paragraph. It is submitted that subsequently application for transfer was made by the petitioner on medical ground in prescribed pro forma, and self-medical ground. Petitioner was medically examined by the concerned chief medical officer of health, and she was concerned chief medical officer of health, and medical report furnished by the medical expert justifies transfer of the petitioner. Stop. It is also submitted that petitioner is suffering from cancer. Next paragraph. During course of hearing, learned advocate representing state respondents has submitted a copy of memo dated 11th April 2025 issued by the District Inspector of Schools within bracket AC close bracket Malda, being respondent number 5, addressed to the Commissioner of School Education, West Bengal, wherefrom it appears that transfer application was also forwarded along with necessary documents to the Chairman, West Bengal Central School Service Commission for taking decision. Next paragraph. In view of aforesaid situation, chairman or the secretary who is to take decision, chairman District Primary School Council, chairman West Bengal Central School Service Commission, being respondent number 4, is directed to decide transfer application of the petitioner, taking into consideration medical report furnished by medical expert within a period of 4 weeks from the date of communication of this order. So, decision to be taken by respondent number 4 shall be communicated to the petitioner by 10 days thereafter. Next paragraph, it is made clear that suspension of portal shall not be a ground to reject transfer application. Next paragraph, writ petition stands disposed of urgent xerox of copy.
Deeply.
Put affidavit of service ta kore. Next.
Next is an HRA matter. Possibly
Next matter.
Item number 17.
Worship, in item number 17, I am told that it is under jurisdiction of DI Barakpur, whereas the party.
This HRA matter, this court is not taking on personal ground. Matter is to be released. Let the matter be placed before the appropriate bench, and thereafter you make it.
My lord.
You are relying upon the order of Justice Saraf.
It is annexed also in the petition, paragraph 28. I have stated also. Yeah.
Next.
I'm for the petition.
এটা কি রিলিজ হয়ে গেল? Yes.
My lord, this is regarding single subject teacher. Kindly come to page 87 for once.
Page 87.
Page 87 is my status. This on general transfer. So, an apparent contradiction. DI sends it back to the school saying that you follow it, but it was upon the DI.
Single teacher. So let the DI take steps in terms of 3rd of January 2022 notification.
There is only one thing, my lord. It is my duty to inform your lordship, my lord. These orders your lordship passed. There is, it was assailed before the Honorable Division Bench, my lord, on that point, that willing teacher that I made submission to Lordship, that kindly do not add the word willing teacher, because willing teacher, nobody will be willing to come for this. That was challenged with the Division Bench. Division Bench has modified, and in one.
I have seen that order, presided over by Justice Sen.
Two
Yes,
orders. One
but
modified.
even then, there also it was observed that strictly in terms of 3rd January.
Absolutely. What my submission was, there are two orders. One is modification, one is setting aside. My submission was that willing teacher is an beyond the notification, it cannot be read because court will not legislate on that. My humble submission before the division bench. Only thing that has been clarified by the division bench, that after the transfer is given, then the resultant vacancy is to be filled up by some other teacher within 6 months period. So my contention was that unless willing teacher will come, I will never be allowed. That was my contention before the division bench. So that is my.
No, division bench directed to legislate if
No.
necessary.
No. Division bench said, that
Yes,
is my humble submission.
that I have seen.
This is my understanding.
It was placed before me in
Yes,
connection with another 3rd January 2022 notification matter.
So kindly, my lord, do not add that willing teacher thing, because it has been clarified by the division bench. That willing teacher, because it is going beyond the statute, it is not there in the statute. That my submission was.
No, there was a modification. You are absolutely correct.
Yes.
But division bench directed that if necessary, DI it will be new rule is to be legislated.
That is, my lord, for the DI to decide. Mine case is
DI to legislate for recruitment.
Whatever the DI.
And Mr. Lahiri, unless and until a teacher is willing, whether he can be compelled.
My lord, if your lordship ask me off the record, I concur to your lordship's view, observation. But
suppose a ex-teacher is working in A.
Yes.
Now he is approached by the DI.
Yes.
So you man the post of you man the resultant vacancy post transfer of Y working in B school. Now if teacher X does not want this, he is not, if he is not ready to perform this, what DI can do? Tell me.
Your lordship is absolutely correct. But so if we go by 3rd January notification, it says otherwise. That has been interpreted by the.
It cannot be compelled. Only on alternative arrangement.
But Gokul.
Well, I'll direct the DI to follow 3rd January 2022 notification issue.
But not to add that willing teacher.
Very well.
That is my prayer.
Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner prays for transfer on the ground of on general ground within bracket distance, being an assistant teacher working in a government aided secondary school. Stop. Application was made, transfer application was made on Utsotsi portal on 24th May 2022, and same was forwarded to the District Inspector of Schools within bracket AC, close bracket, Purbo Medinipur.
Yes.
AC Purbo Medinipur being respondent number 5, but said respondent number 5 in his turn returned the transfer application through portal on 20th June 2022 to the school authority where petitioner is presently working, since petitioner was found to be a single teacher in the school. Since petitioner was found to be single teacher in the subject in the school, it is submitted by the learned advocate representing the petitioner that instead of sending the matter back to the school authority, respondent number 5 ought to have made an effort to give effect to the notification dated 3rd January to the government notification dated 3rd January 2022 by making alternative arrangement in the school where petitioner is presently working. Next paragraph, state respondents and West Bengal.
State is not appearing.
West Bengal Central School Service Commission is represented by learned advocate. Stop. It is submitted on behalf of commission that it is the duty of the respondent number 5 to make alternative arrangement in the school where petitioner is working instead of sending the matter back to the school authority. Effort should have been made by the respondent number 5 to take steps in terms of such said notification dated 3rd January 2022. Next paragraph. Having considered the respective submissions made on behalf of the parties, writ petition stands disposed of, directing respondent number 5 to make an endeavor to provide alternative accommodation strictly in terms of 3rd January 2022 notification in order to facilitate transfer of the petitioner. Stop. If alternative arrangement is made in terms of notification dated 3rd January 2022, a petitioner shall immediately be transferred to the transferred based on transfer application dated 24th May 2022. Stop. Writ petition stands disposed of. Urgent direction.
My lord said after arrangement then transfer, but division bench said otherwise.
I have seen the order of the division.
Resultant
Mr. Lahiri, I have seen. Yes.
Resultant vacancy.
Item number 19.
This is an HRA matter.
We are relying upon that judgment. HRA matter released.
Item number 20.
I am for the secondary board lordship.
I'm paying for a short pass.
Led by
Mr. Chandrasekhar Banerjee. Don is like, I'm paying for a short pass.
short passover is not possible.
Lordship, HR matter lordship.
Yes,
HR matter lordship.
HR matter means
House rent lordship. House rent allowances lordship.
let him place his case.
Her was that is her HRA since August 2014.
Petitioner?
Her HRA was seized since August 2014.
HRA was
seized
since
August 2014. For my lordship, an order judgment kindly comes to Annex 12, page number 32.
Oh, you are relying upon this judgment dated 16 March 2021, then it is to be released. Yeah. I'm not taking this HRA matter where reliance is placed on judgment dated 16 March 2021 on personal ground. Same order, released.
Item number 21.
Yes, yes.
Implementation of the order judgment which was I was one of the petitioners. Justice Sarah delivered judgment by the same line in Calcutta. It's a honest to the judgment was there that I completed after the honors when I joined there. They might have completed.
Who is appearing for the state? Higher scale. So then serve another notice. Without state, matter cannot be decided. We have served notice right 12 June 2025.
Not today, but I am searching.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. In spite of service of notice, state respondents are not represented. Stop. Next paragraph. Learned advocate representing the petitioner is directed to serve notice upon the learned advocate representing the state respondents by 7 days from date. List the matter under the same heading on 10th July 2025.
Item number 22.
Yes.
When the application for necessary spending it was made offline in the prescribed protocol.
In the
prescribed protocol. Distance ground.
Distance ground.
Distance.
Where is the application?
Well, application page 22.
When the application was made?
This application was made.
Okay.
বাড়িদা প্রথম পাতা দেখুন 21 পাতা দেখুন 5-3-25
না ওটা তো নো অবজেকশন হয়েছে
প্লেয়ার ফর জেনারেল ট্রান্সফার 21 পাতা
এই সিভাবে একটু চেম্বারে পাঠাবি ডিআরএসি ফাইলটা নিয়ে আসতে
When school received, page 21, when school received.
Well, page 21, my lord, the
When school
received, my lord, on 5th March 2025.
Or 25th.
25th March, my sorry, my lord. 25th March.
Yes, now where is the difficulty? Because school has issued no objection.
Yes, madam, the 26, it is the
March 2025.
March 20.
Yes.
As per his averment, my lord, the application has been submitted.
This is
on
his
5th March.
application, allow him to place his case.
No, no, my lord, date, my lord, date.
Now your lordships can see the
Now this is an application on what ground? Distance?
distance.
Distance ground.
Distance ground.
Yes. Now where this application is pending now?
Well, the distance is pretty- well, because the application page 24, your lordships kindly have a look. It has been forwarded by the
Yes. What do you want to submit?
No, my lord, I just.
Mr. Bandyopadhyay?
My lord,
My lord, according to my lord, the
No, first he was trying to make some
I was trying
submit.
to say the date. My lord, as per his averment,
Yes.
the application has been submitted on 5th March.
5th March.
5th March. And my-
Yes, now since the issue is pending before the DI, let it be decided by let it be forwarded to the commission. And commission shall
This is
take
an
decision.
offline application.
Offline application.
Previous my lord, portal application, those who are, my lord, he has averred. My lord, those were rejected on the ground of either low ranking or, my lord, the CMOE did not, my lord, certify.
That is on medical ground.
Medical ground, maybe.
Now it is on the ground of distance.
Ground of distance, that distance is also, my lord, between the, my lord, working place of the, my lord, spouse. 330 kilometer, more than 330 kilometer. That ground has been taken in the petition. I don't know, my lord, what was the.
Oh, both the husband and wife are working at separate different places, and the distance is. But that cannot. That is also a ground for consideration. No.
No, my lord, that is no more a ground, my lord. In other grounds, as per the amended provision. My lord,
No, where is the place of residence of the petitioner? From place of residence, what is the distance of your present school?
330 kilometers. Well, from the place of residence to the school.
Not from the place of work of your husband.
The place of residence is that I have said, my lord.
Malda.
Malda is the resident of the Malda. And my lord, the para 9, if your lordships can consider, 8 years old child, minor son.
My lord, para 9 he has averred. The petitioner has been subsequently.
Now, if your husband is transferred from Malda to Darjeeling, then what will happen?
No, that is.
Yes. The government.
yes.
Director of Agriculture in Malda. Now, if he is transferred to Darjeeling, then what will happen? Again, she will make an application and show me that the place of work of the husband is a consideration under the rules for making a transfer application on the ground of distance.
So, my lord, I want not only the place of spouse, because I had the minor sons that I have made a categorical step.
That is not a ground.
Well, this is the.
If you have a minor son, that is not a ground of transfer.
But distance is a ground. The distance.
But distance is a ground. Distance is a ground on what basis? Your husband is working somewhere else.
Today my husband is working in the 330 kilometers away from me. You also can see that.
Where you are working?
The husband's working place.
No. Where you are working? Malda. And husband is working in North 24 Parganas.
No. Srirampur Hooghly.
Srirampur Hooghly.
Srirampur.
Yes, Srirampur Hooghly, right.
Yes.
Page 21.
Yes. Anyhow, my lord, you will without going into the merit when the matter is coming, I forwarded the.
But the rule says that if distance of the present school and the school where you are seeking transfer is more than 25 kilometers.
Yes. Should not.
Well, the distance is the present school is the district of Malda. If I seek transfer in the district of Hooghly, that is more than 300 kilometers.
But where is your permanent residence? Where is your permanent residence?
Permanent residence is the district Malda. But district Malda, from district Malda, I am not the.
Because your husband is in transferable job. He has been transferred to this Sirampur Hooghly.
Yes.
Now, if after 1 month, if you are transferred to Sirampur Hooghly, thereafter, if your husband is transferred to
No,
Siliguri,
no, question is my husband is the permanent resident of Calcutta. My husband is not the transferable that the today is Hooghly, tomorrow is the Darjeeling. He is the permanent resident of the Calcutta.
well, you take decision in accordance with law. Since it has been forwarded by the DI,
is to take.
yes. On the ground of distance, strictly in terms of the relevant rules, you take this. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner made transfer application in the prescribed pro forma.
যাবো তো তবে এটা না করে যাবো কি করে?
In the month of March 2025, and the school where petitioner is presently working has issued no objection on 26th March 2025. Stop. It is submitted by Mr. Bari, learned advocate representing the petitioner, that video letter dated 2nd April 2020, school authority forwarded transfer application of the petitioner to the District Inspector of Schools AC Malda for taking steps. Prayer is made for giving direction upon the respondent authorities for consideration of transfer application of the petitioner. Next paragraph, state respondents and West Bengal School Service Commission, West Bengal Central School Service Commission and board are represented by learned advocates. Stop. It is submitted that since issue is pending before the before the respondent number 5, same needs to be forwarded to the West Bengal Central School Service Commission for taking decision. Next paragraph. In view of respective submissions made on behalf of the parties, respondent number 3 is directed to forward transfer application of the petitioner in offline mode to the Chairman, West Bengal Central School Service Commission, being respondent number 7, by fortnight from date if same has not yet been forwarded. Stop. On receipt of transfer application, respondent number 3 is directed to take decision on the same within a period of 6 weeks thereafter. Stop. Decision to be taken by the respondent number 7 shall be communicated to the petitioner by fortnight thereafter. Next paragraph, it is made clear the suspension of portal shall not be a ground to reject transfer application of the petitioner. Writ petition stands disposed of, urgent xerox.
Could be subject to should be respondent number 7 to take decision. Your Lordship has said 3 perhaps.
No, 3.
না না জসেফ ঠিকই তো বলেছে।
Lastly, to take decision.
দেখো তো
chairman.
না জসেফ বলেছেন ডিআই কে ফরওয়ার্ড করতে এসএসসি কে, এসএসসি উইল টেক ডিসিশন।
7.
Very good. Great.
চলো
Item number 23.
At the outset, I must submit this is in respect of higher education college.
Then I don't have termination.
So I'm pending for the board.
At the time of at the time of learned advocate representing the petitioner submits issue involved in this writ petition relates to college education.
College education.
College education. Stop. Hence, next paragraph, writ petition stands released due to want of determination and be placed before the bench having determination. Then why you have classified it as higher secondary education? Leave is granted to the learned advocate for the petitioner to amend the presentation form and reclassify the writ petition as college education matter.
Liberty to mention.
Next.
Item number 24.
Amendment করেন
With Mr.
Yes.
Malap, page 25 is the subject matter of the challenge. January 1st, 2026.
January 30.
31st.
When this objection was raised,
No, I will retire. I will retire from my service on 31st January 2026. This objection is raised, but the ground of the objection of the incremental benefit of the additional
increment.
should 3%. Due to upgradation of the school, the hassle is school. And still I am enjoying. The fixation has been made 3% additional increment. Now there is an objection.
but without permission, it is not allowed.
Permission is not required.
Yes, every day court is disposing of the matters, directing the Commissioner of School Education to take decision. Without formal permission, it is not automatic, Mr. Badi.
Upgradation, after upgradation of the schools, the hassle the schools. The additional increment I'm entitled, that has been your lordship, I should not defeat.
But it has to be approved by the
Yes. It has, the fixation has been made.
The fixation has been made by the school authority, but incremental benefits every day there are at least 10 to 15 matters, and court is directing the commissioner to take decision. What for?
Now that is different issue. Here, my lord,
Why different that is?
because of the one additional increment due to upgradation is not allowed without the permission of the concerned authority. It has already been allowed.
Show me that by an order DI has allowed it.
Under what basis they are raising this objection in terms of their earlier memo, which has been set aside?
No, that has to be sanctioned by the authority. It's not an automatic exercise.
If it is not sanctioned by the authority.
Suppose today you are working as an honors graduate teacher.
Yes.
You have obtained with the permission of the DI postgraduate qualification in the relevant subject. Whether drawal of pay in postgraduate scale is automatic or with the approval of DI, tell me.
No. Question is, if your lordship delegated the matter to the authority, no problem, but keeping in view of that judgment of this court.
Yes, that should be the procedure. Straight away, since you are a teacher, if it is not approved, then you should not. You should have forwarded the issue to the concerned district school for granting approval.
Yes, approval.
How this can be automatic, Mr. Badi?
District inspector schools.
So according to sweet will of the school authority and the teacher concerned, pay fixation is to be made.
Pay fixation has been made, page 18.
Wrongly made. If it is not without any approval, Mr. Badi.
That has not been spelled out in the impurity.
Wrongly made. No, I am not saying that grant or non-grant of 3% additional increment.
Yes.
I am not making any comment. But in a way, this has been drawn by the petitioner is not the appropriate way.
If it is forwarded to the, because I was appealing to
what for court in all other matters is giving direction upon the Commissioner of School Education to take decision, placing reliance upon judgment of the division bench and single bench.
I was there on matters, lordship delegated the matter. That decision was not taken.
Show me that every day. Show me that any decision has been taken by authority permitting you to enjoy 3% additional increment.
That are not permission techniques.
The 3% additional increment pay fixation has been made by the district inspector schools, rightly, wrongly, whatever it may be, but it has not
been. Show me that
said,
pay fixation has been made by the.
That page 18, page 18. Page 18, P4. Column. Former post one additional increment in the district pay scale.
This is done by the school authority.
No, no, no.
Then signed by the DI.
Signed by the DI.
Yes, it has been made by the school authority.
Counter signature.
Where is the formal approval? Today, if an honors graduate teacher enjoying honors graduate scale of pay starts drawing pay in postgraduate scale on the pay fixation made by the school authority, and that has been countersigned by the DI, that is final.
That on relying that principle, well, every
There
day,
has to be an order by the authority.
every day we are receiving this order. Relying the principle laid down by the other benches.
It's not an automatic exercise.
If you lordship delegate the matter, no problem.
Yes,
because
yes.
matter issue has already been settled. That notification it has been set aside. And appeal was taken out, appeal court didn't interfere.
Yes, right.
So if you
Kalishadan Bhattacharya's order.
if you lordship delegate the matter, no problem. I was suggesting the futile exercise.
No, but it
Because
is
of
not
the
an
fact-
automatic, it should not be an automatic exercise. That will be misused by the teachers. You know very well, Mr. Badi. Yes. No, no, no. Suppose you are not enjoying this honors graduate scale of pay, a postgraduate scale of pay. By obtaining qualification, we will start enjoying it without approval.
If the procedure is followed,
Then there will be no checks and balances. And there will be an anarchy with regard to fixation of pay.
anyhow, your lordship, my lord, I should not argue when your lordship.
No, answer, satisfy my query.
I was appealing to your
Then
lordship.
what for other teachers are every day filing the writ petition? Because a present petitioner is also working now. Filing the writ petition, seeking direction upon the commissioner to get an order from the commissioner.
That is not the case. Here, my lord, the retirement date is 31st January.
31st January 26.
Very well, excluding your incremental benefits, you enjoy the retirement benefit. Let it be decided on affidavit. Let it be decided on affidavit.
No, I am asking that.
With incremental benefits, if you want to retire and get the benefit, then there has to be a formal order by the authority.
Yes.
It is your lordship, the formal order is being given. I believe hundreds of matters are being disposed.
But there is no representation by the commissioner,
No,
by the petitioner.
No, I challenge the decision.
No
I
representation.
challenge the decision. Your lordship, the question of representation, I challenge the decision.
Yes,
Page
that
25.
page 25.
Plus 25.
Then let me direct the commissioner to take decision.
Whatever, or DI can do that. Secretary of Education can do that. Whatever your lordship.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Mr. Badi, learned advocate representing the petitioner, submits that assistant teacher.
Headmaster.
Mr. Learned representing petitioner submits that petitioner is to retire from the post of headmaster on superannuation on 31st January 2026. Stop. While processing pension case of the petitioner, District Inspector of Schools, Murshidabad, being respondent number 4, being respondent number 4, raised objection on eligibility of the petitioner to draw 3% additional increment. Why it has been stated one increment? Come to page 25. One increment due to upgradation of HS section.
That will be the one increment.
It will be 3 additional increment. 3% additional increment.
3% additional.
কি বলছিলাম? To draw additional increment for manning the post of headmaster in upgraded higher secondary school. Stop. It is submitted. Respondent number 4 respondent number 4 should not have raised objection while settling pension case of the petitioner, since issue is no more recently grant. In VY, देखिए ये usual order टा दाओ तो 3% additional increment है. সকালবেলায় দিলাম অনেক
Your lordship is relying the Kali Sadam, but
Kubir Ghosh and Kali Sadam.
Somanindra Adok, your lordship has gone through that. Somanindra Adok.
Yes, there are several orders. I am relying.
It is a very, the entire discussion was, Kalishadan was the recovery. And your lordship kindly have a look to this.
Yes, দাও তো যেটা দিচ্ছে হ্যাঁ ওটাও দাও উনি দিচ্ছেন যেটা দাও একটা রেখে দাও এটা বলে দাও হ্যাঁ কি বলছিলাম in view of order dated 7 January 2025 passed by Honorable Division Bench on an intra-court appeal being FMA 981 of 2022 within bracket Somarendranath Adok versus the state of West Bengal others. Stop. It is submitted that in view of the law, it is submitted on the strength of ratio decided in Somarendranath Adok Supra. Petitioner is entitled to enjoy 3% additional increment, being headmaster of upgraded higher secondary school. Next paragraph, state respondents are represented by learned advocate who has opposed the prayer of the petitioner on the count that there is no formal order passed by respondent number 4 or Commissioner of School Education West Bengal granting incremental benefits, additional incremental benefits in favor of the petitioner in consideration of the fact that petitioner is working as headmaster in an upgraded higher secondary school. Next paragraph. In view of the respective submissions made on behalf of the parties, the writ petition stands disposed of, directing the Commissioner of School Education West Bengal, being respondent number
2, my lord.
2, to decide entitlement of the petitioner to enjoy or to receive 3% additional increment, being headmaster of upgraded higher secondary school. On following ratio decided in Somarendranath Adok Supra. Stop. Respondent number 2 is also directed to consider the ratio, ratio of the judgments delivered in the state of West Bengal and another versus Kalishadan Bhattacharya alias Bhattacharya and others, decided by the Honorable Division Bench on 15 January 2024, and a ratio of the judgment delivered in Shubir Kumar Ghosh versus State of West Bengal and others, decided by a coordinate bench on 15 January 2024. Stop. Respondent number 3 shall take a reasoned decision within a period of 6 weeks from the date of communication of this order after granting opportunity of hearing to the petitioner or his representative.
That is 2 হবে, respondent number 2.
Respondent number 3 বললাম, 2 করে দাও. Stop. The decision to be taken by the respondent number 2 shall be communicated to the petitioner by 10 days thereafter. Stop. such decision is also to be communicated to the respondent number 4 for expeditious settlement of pension case of the petitioner. Prior to superannuation of the petitioner on 31st January 2026. Stop. Next paragraph. Writ petition stands disposed of, urgent xerox certificate. Next.
Item number 25. 3% increment. The headmaster of the upgraded high secondary school. My lord's judgment I have.
You are for the state.
For the state.
Have you made it whether you are working or retired?
Working, but not made a representation. My lord will kindly give me the presentation.
That is fine. He is disposed of. দেখে করবে তুমি দেখে দেখেও মামলাগুলো ভুলভাল করছো অর্ডার গুলো ফর্টনাইট হবে এখানে হ্যাঁ দেখুন ইউজুয়াল অর্ডারে ভুল করছো কেন কারেকশন হয়েছে ইয়েস নেক্সট
Item number 26.
Lordship, I appear for this.
ঠিক লিখেছেন আপনারা আপনি জানান আমি স্টেটমেন্টটা নিয়েছেন আমি স্টেটমেন্ট
ইয়েস
I retired from the service
নাম দিয়েছেন আমি তো
on 31st January 2025.
নাম দেয়নি ম্যাম
Objection was made on 23rd December 2025.
Page 30, 33.
Event will stop from 1st July 1993 on trade and will start after completion of the base yes. Hence, the bill to be returned in part from serial onwards
and what your amount to be calculated up to the service. Okay. This is
Joint Director of Accounts. Yes.
okay. 1992-93 session. I took admission in the BA. 92-93 session. Now, out of the issue.
Yeah.
They holding practical examination by the Calcutta. And this within 1 year it could not be completed. That matter, I have stated clearly para 15. Because after joining, she required to complete with 5 years.
Yes.
5 years. But
So this 5 years completed in July 1993.
yes.
And next month you obtain bonus.
But what is the reason? Reason was due to non-publication of the result by the university itself.
You are appearing for the state.
Lordship for the state.
You are for? Both are for the state.
Lordship, she is also.
So, the recovery and also the recast of the pay.
When this order was passed, saying 23rd of December 2024. First of all, recovery is not permissible in terms of Rafik machine. So they,
Also not permissible. Recast.
recast is permissible for the purpose of fixation of pension.
That is,
There is no bar in recasting your pay for the purpose. Yes.
Health the case is different.
Yes.
The publication of the result was not done due to fault of the investment. If I have voluntarily, I could not complete it, then I took admissions, other cases.
What was the session for which you took admission?
Only the publication was, the result was made after the time is over.
But the course was complete. When course completed?
Page 50, paragraph 15, with the losses can Para 30, I have given the date also.
24th of August.
Yes, why the state authorities did not raise objection
Lordship, we have to seek
within
instruct-
time?
Allow us to file a report, man.
What report you will file?
Instruction is required. Lordship.
Because petitioner was to complete the B.Ed qualification or obtain B.Ed qualification within 5 years.
Yes.
Now, there was a delay of 1 month, 24 days. And the qualification completed her B.Ed qualification on 24th August 1993, which is the last date of B.Ed practical examination. Classes probably dissolved, classes were over prior to that. time when the classes ended. Examination might have held belatedly in on and practical examination completed on 24th August 1993. But when the
paragraph 6 that the DED clinical course was completed on 15th and College of
course was complete on 15 May 1993. But if the examination was not held, why petitioner will be penalized?
Allow us to come up with a report, some instruction at least. It is needed. It is a peculiar case, it's needed. Allow me to come back, my lord, I'll satisfy you.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner retired on superannuation on 31st January 2025 from the post of assistant teacher and on 23rd December 2024 Joint Director of Accounts Office of District Inspector of Schools AC Howrah being respondent number 6 raised objection for sanction of incremental benefits in favor of the petitioner upon treating the petitioner as trained teacher from 1st July 1993. Whereas according to the state authorities, petitioner was entitled to receive such increment from 25th August 1993. Taking note of first last date of practical examination. On 24th August 1993. So next paragraph. Mr. Bari, learned advocate representing the petitioner, submits upon placing reliance on the statements made in paragraph 6 and 13 of the writ petition that B.Ed course was complete for the session 1992-93 for the session 1992-93 on 15th May 1993 by dissolving classes. But due to delay in holding practical examination within the stipulated period of 5 years, petitioner could not obtain B.Ed qualification, for which petitioner should not suffer. Stop. Next paragraph. Learned advocate representing the state respondents has prayed for accommodation to file a report. Stop. Let report be filed by the District Inspector of Schools, AC Howrah, being respondent number 3 by 10 days from date, with an advance copy upon the learned advocate representing the petition. Next paragraph. List the matter under the same heading on 14 July 2025.
Obliged.
Item number 27.
Yes.
Higher scale of pay. Well, I
Right.
was pursuing my part one. Before joining the position.
Any decision was taken? Yes. To show me your approval of appointment.
Approval of appointment is at page 30.
Page
30, 30.
Which serial number?
Serial number 4.
Yes. Then
representation, last
no, no. You are tell me the facts, relevant facts.
I was pursuing this master degree in the same subject.
Master degree in which subject?
In education. That was my area of teaching.
But whether you were appointed in normal section or higher secondary section?
Normal education, higher secondary education.
Where from you are getting this?
That's page 30. The approval itself.
Yes.
The third last column on the right. HS.
Yes, 33rd last one.
Yes, then you are appointed as an assistant teacher in higher secondary section in education. Then on 1st November
To that, with the leave of the management committee, I completed my post-graduation course. In 2000.
Now, at the time of appointment, what you were doing? You are at which
I was
stage
pursuing
of your postgraduate study?
I had joined the post-graduation course in 2006, and examination, of course, was in 2008 itself.
Part 1 or part 2?
Part 1 examination.
Give me the details.
Yes, Miller. Kindly comes to
Read petition para 7
page
to
20. Page 26 is my admission.
From which university you obtained qualification?
Netaji Subhash Open University. Page 26 is the admit card.
Yes.
I joined in 2006 in this post-graduation course. I gave part 1 examination, final examination in December 2008. Thereafter,
But it says date of commencement is 4th January 2009. Page 26.
Of the examination. No. This would be the examination. Because the course I joined in 2006.
And it was you completed the course in 2010.
10.
So why 4 years? It's a duration of it's a 2 years course.
Distance mode it was there.
Yes.
So that liberty was there, my lord.
Show me any document that you took admission in 2006 and completed in 2010.
Age 25. This is the admission degree.
It is in 2007,
7.
not 26. Not in 2006. And there is an interpolation. It was written 6, then it was made 7.
Other dates are also there.
What is this? 1st of July 2006. 6 was then made 7.
7.
Yes.
That is there, my lord. I cannot improve this. I cannot improve.
Who has done this?
It was done by the authorities. Instruction level. It was done by the authorities, I am told, my lord.
And when you completed the course? Where you have stated in the writ petition that you took admission in 2006.
Writ petition. Paragraph number 3 at page 3. Your petition states that on July 1, 2006, he took admission for MA in education in Calcutta Open University.
And completed course when?
2010.
Yes, para 7 on 31st January 2010. The date of last date of final examination.
Do you have a copy of the order which I passed in similar other matters?
I can supply in a short while.
Last order.
Oh.
Yeah. Workshop, it is annexed to the writ petition itself. Page 65 onwards.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. So, petitioner is an assistant teacher in education in higher secondary section of a government aided school and has laid claim for sanction of postgraduate scale of pay on acquiring postgraduate qualification in relevant subject. Stop. It is submitted by the learned advocate representing the petitioner that petitioner was that he was appointed as an approved assistant teacher on 1st November 2008, and prior to his appointment, he was undergoing postgraduate course with effect after taking admission on 1st July 2006 through taking admission on 1st July 2006 in Netaji Subhas Open University. So, it is submitted that petitioner obtained postgraduate qualification through distance mode of education from Netaji Subhas Open University in 2010. Therefore, at the time of his appointment on 1st November 2008, he did not get opportunity, or therefore after appointment on 1st of November 2008 as an approved assistant teacher, he did not have any scope to seek prior permission from the concerned district inspector of schools AC. North 24 Parganas for enrolling himself in higher course of study. In this regard, reliance is placed on the judgment of the Honorable Division Bench dated 11th February 2021, passed in Adilus Zaman versus State of West Bengal and others. Stop. It is also submitted that the ratio of Adilus Zaman Supra has been affirmed by the Honorable Special Bench. Vide judgment dated 7th February 2024 on a batch of matters. First one being WPA 9921 of 2007, Utpal Kanti Karan versus State of West Bengal. Next paragraph. State respondents, next paragraph koro. Next paragraph. State respondents are represented by learned advocate. Have you made any representation?
Yes. Representation. Page 48.
Page 48.
48.
Page 40.
48.
48. When it was received, 25th March. So after filing this writ petition on 25th March, you have filed the writ petition in May. After filing this representation in 25th March, after 1.5 months, who has learned advocate who has submitted that representation has been made on 25th March 2025 to the respondent number 4, seeking sanction of postgraduate scale of pay. So it is further submitted that it is further submitted that since the issue is pending before the respondent number 4, the same is required to be decided in accordance with law. Next paragraph. Having considered the respective submissions made on behalf of the parties, writ petition stands disposed of, directing respondent number 4 to decide the claim of the petitioner seeking sanction of postgraduate scale of pay on consideration of the representation dated 25th March 2025 within a period of 8 weeks from the date of commission of this order. Stop. Decision to be taken by the respondent number 4 after granting opportunity of hearing to the petitioner or his representative, and the rescind order shall be passed. Stop. While taking such decision, respondent number 4 shall follow the ratio of Adilus Zaman Supra and Utpal Kanti Karan Supra. Stop. Next paragraph. Decision to be taken by the respondent number 4 shall be communicated to the petitioner by fortnight thereafter. Urgent Xerox certificate copy. All the fixed matter.
Item number 250.
Thank you.
এইটা লাগবে। Last date you relied upon a judgment 2011 7 SCC 397.
Yes.
That was the first one.
On the principle that Lord, there has to be an existing legal right, seek mandamus. But that was the principle on which Lord that judgment was.
Yes.
Twenty 2021 volume 5 টা দিয়ে দাও। Lord, the next subject.
Yes. Now, Mr. Court, this interim order which was passed on 1st August 2016 by a coordinate bench
Yes.
on this writ petition that is still existing.
Yes, I think we have not. Yes.
It is subsisting.
But lot of things happen in the meantime
Yes.
because
Matter went up to Supreme Court,
Supreme
then
Court
came
and
back,
then
division
remanded.
bench, orders.
Yes.
But I'm just that's why I'm asking whether that interim order still exists.
Because the division no, we have not encumbered the posts. The posts are there, but Lord, just I am wondering because division bench কি করেছিল dismiss করে দিয়েছিল writ allow করে দিয়েছে and that judgment has been set aside by the because Lord, governing order should be the last order passed by the Honorable Supreme Court.
Yes.
Because Lord, whatever interim order was initially passed, that got merged into the order of the division bench. Because the matter traveled in appeal and then Lord got merged with the order of the division bench, which ultimately went to the Supreme Court and the order was set aside. But Lord, we have not affected those posts.
Yes.
It is
for my understanding.
yes, of course.
Court noted the interim order at the time of disposal of the SCP and say and observe you could have informed me before because the same judge of the case. Yeah,
Very well. I have not found any reflection in the order of the Supreme Court. My learned friend will correct me. That reflection is not there in the order of the Supreme Court. That's why I made this submission. But what we have, in any event, we have not done anything. That's huh? Yes.
Yes.
Now, Lord, the next point on which, Lord, I wish to address is the policy decision. How to be tested, then, Lord, scope of interference on this. Lord, the first judgment I wish to cite is 2021 volume 5 SCC, page 638. Judgment.
Yes.
Lord, Lordships can take the facts of the case from Lord.
Which paragraphs you are relying upon?
Lord, discussions are from paragraph 40 onwards. I'll be relying on para 40, 41, 43 and 45. Lord, the facts are available at paragraph 3.
3 and 4.
Yes.
Lord, kindly, my lord, see, the rules are, my lord, discussed in paragraph 3 and 4.
Oh.
And then, my lord,
2020 code, yes.
then, Lord, there was a shift on the stand of the commission. And Lord, that shift is under challenge because, Lord, paragraph 7, your lordships will find that the commission wanted to conduct a preliminary examination, which was objected to. Then, Lord, there was a revised choice which was permitted. And Lord, this go on. I'm not really, Lord, please come to paragraph 40. The thrust of the submission, has your lordship got that?
Yes.
Of the learned counsel for the petition was that the discretion has been exercised by the respondent as a matter of policy in the earlier selection, and the present petitioners have a legitimate expectation that the government must exercise its discretion to overcome the unprecedented situation which the petitioners have faced while appearing in the examination in 2020, and their right of fair consideration and effective participation in the selection process has been denied to them, which is in violation of Article 14 and 21 of the Constitution. The submission, in our view, is without substance for the reasons that the policy decision which had been taken by the executive on earlier occasions, of which a reference has been made, always depend on the facts and circumstances at the given point of time and have to be tested independently in the circumstances in which it has been exercised by the competent authority or the first respondent as in the instant case. Then, Lord, please come to paragraph 43. It is the settled principles of law that policy decisions are open for judicial review by this court for a very limited purpose, and this court can interfere into the realm of public policy so framed if it is either absolutely capricious, totally arbitrary, or not informed of reasons, and has been considered by this court in Union of India such and such. Then, Lord, the two paragraphs.
What you wanted to do, it relates to the facts. What you wanted later.
47 and paragraph 47 is set out. There is one more reason due to which we are unable to subscribe to the view taken by the Madras High Court and the Delhi High Court. The horizontal reservation and relaxation for physically handicapped category candidates for civil service examination is a matter of government policy, and the government, after considering the relevant materials, has extended relaxation and concession to the physically handicapped candidates belonging to the reserved category as well as general category. It is not in the domain of the courts to embark upon an inquiry as to whether a particular public policy is wise and acceptable or whether better policy could be evolved. The court can only interfere if the policy framed is absolutely capricious, non-informed by reason, or totally arbitrary, offending the basic requirement of Article 14 of the Constitution. Then, Lord,
so that is the contour within which policy can be interfered with.
Frame. Now, Lord, if your lordship finds, Lord, just adding a sentence to this, if your lordship finds that a policy conforms to the existing law or the existing rules or the existing policies, then, Lord, the scope for interference with that policy is in judicial review, in my humble submission, is not there. Because, Lord, what the government said, that you bring the policy in line with the policy of the Goa shipyard or the other similar similar organization which is having similar policies. So, because, Lord, government is one employer, it must have a policy which is in consonance with the policy which is there in the other organization. There can't be a policy, my lord, bereft of the existing policies. So basically, my lord, the policies which is taken note of, because the insisting letters are that you follow Goa shipyard and the DOPT guideline, which is the standard guideline prescribed by the government, and it expects that all the organizations adopts that as part of their policy. So this is what it says, that it is not in the domain of the courts to embark upon an inquiry as to whether a particular public policy is wise and acceptable, or whether better policy could be evolved. The court can only interfere if the policy framed is absolutely capricious and non-informed by reasons, or totally arbitrary, offending the basic requirement of Article 40. Because, Lord, what happened in this case was, Lord, in the first three categories of people who were taken in, they were taken in as a temporary hand. And, Lord, subsequently, without a notification, employment notification, they were absorbed and given a permanent status. So this is what was stopped by the government, saying that either you frame a policy which is in consonance, a compassionate appointment policy, which is in consonance with the other organization, and you proceed with that. You cannot proceed with a policy where you fill up all the posts, available posts, by temporary employment, and then you appoint these persons, which is directly violating Article 14 and 16, because that is what Uma Devi is, that you can't give backdoor entry. Now, Lord, kindly come to 45. Judicial review of a policy decision and to issue mandamus to frame policy in a particular manner are absolutely different. This is one thing to say that I am taking a judicial review of the policy decision, and the other is directing the authority to frame policy. It is within the realm of an executive to take a policy decision based on the prevailing circumstances for better administration and in meeting out the exigencies, but at the same time, it is not within the domain of the courts to legislate. The courts do interpret the laws, and in such an interpretation, certain creative process is involved. The courts have the jurisdiction to declare the law as unconstitutional, that too where it is called for. The court is called upon to consider the validity of a policy decision only when a challenge is made that such policy decision infringes fundamental right guaranteed by the Constitution or any other statutory right. Merely because, as a matter of policy, if the first respondent has granted relaxation in the past for the reasons that there was a change in the examination pattern syllabus, and in the given situation had considered to be an impediment for the participation in the civil service examination, no assistance can be claimed by the petitioners in seeking mandamus to the first respondent to come out with a policy granting relaxation to the participants who had availed of a final and last attempt or have crossed the upper age by appearing in the examination 2020 as a matter of right. Now, Lord, merely because 2006, based on 2006, some temporary appointments were given, one can't come and say that that policy must be followed to give us also the temporary appointment based on that. And especially when there was no recruitment rules, nothing at all. So this is what is commented upon. It says that merely because in the past something is done, it can't be insisted upon to continue with the same. This is what is stated. Lord, in fact, your Lordship has taken note of, Lord, paragraph 41 also. Yes. Where, Lord, this contention raised in paragraph 40 was rejected. On the ground of Article 14 and 21, the concession which was given was, mandamus was sought that should be continued. 41, the court says the submission in is without substance for the reasons that the policy decision which had been taken by the executive on earlier occasion, of which a reference has been made, always depend on the facts and circumstances at a given point of time and have to be tested independently in the circumstances in which it has been exercised by the competent authority or the first respondent as the instant case. So, Lord, the shift of by which the 2013 policy has been framed, the facts and circumstances leading to that policy will have to be taken into consideration. This is what it says. Some concession was shown in certain years. So, my lord, by a mandamus, this was claimed that that concession should continue even in the current year. Supreme Court turns down that, saying that it's a matter of executive to lay down the policy. Now, my lord, the next judgment on this, my lord, is reported in 2023, volume 14. SCC, page 376. Lord, for facts, kindly see paragraph 325.
Tell me the paragraphs.
I will give you lordships the paragraph. 3 to 5 for the facts. 16, 20, 25 and 26. But kindly take paragraph 4. After completion of 8 years of service, the respondent writ petitioner claimed UGC scale of pay as paid to the persons in the senior scale of librarian in colleges under the Higher Education Department as per Madhya Pradesh Educational Service Recruitment Rules 1990. The request of the respondent writ petitioners for the higher UGC scale of pay was not acceded to. The respondent writ petitioner therefore filed the writ petition referred to above, which has been allowed, and the respondent writ petitioner has been directed to be paid UGC scale of pay as paid to the librarians of colleges under Higher Education Department. An intra-court appeal filed by the appellants has been dismissed. So, my lord, now kindly please come to paragraph 16.
Yes.
The court took note of the submissions of the Learned Council for the state of Madhya Pradesh that University Grants Commission scale of pay had not been extended to the employees of the Ayurvedic colleges, including the members of teaching staff government by the 1987 rules. So basically, it says that in so far as the Ayurvedic college is concerned, UGC scale has not been extended. Then, Lord, your lordships will kindly come to paragraph 20.
Yes.
It is also well settled that there can be no equality to a wrong and or illegality. Just because librarian may have erroneously granted the UGC pay scale, that would not entitle others to claim the UGC pay scale if not applicable under the rules. But there was no recruitment rules when these three lots were given appointment on temporary basis. And Lord, this was stopped. So, Lord, basically it's saying that if the executive feels that this is not to be continued and with a proper scheme it should be continued, then Lord, it says it can't be, no equality can be claimed in respect of those where
Erroneously granting scale
or appointment. Then Lord, please come to paragraph 21. Your lordships will find that kindly come to about 4-5 lines from the top. It a sentence starting with the word "it was urged that," has your lordship. Specific rules for the employees of Ayush department was framed only in 2013. Prior to 2013, there were no rules, and such rules could not retrospectively be applied. However, from the recital of the rules, it is patently clear that the rules have been framed superseding the 1987 rules. This makes it absolutely clear that at material time, for point of time, the employees of Ayush Government Madhya Pradesh were governed by a separate set of rules. The fixation of scale of pay is a matter of policy. Then, Lord, please come to paragraph 24. There are, Lord, certain quotations from State of Uttarakhand versus Sudhir Budakoti. Has your lordship got that? Paragraph 24.
Yes.
Kindly see, it talks about Article 14. It says a mere differential treatment on its own cannot be termed as an anathema to Article 14 of the Constitution. When there is a reasonable basis for a classification adopted by taking note of the exigencies and diverse situations, the court is not expected to insist on absolute equality by taking a rigid and pedantic view as against a pragmatic one. Such a discrimination would not be termed as arbitrary, as the object of the classification itself is meant for providing the benefits to an identified group of persons who form a class of their own. When the differentiation is clearly distinguishable with adequate demarcation and duly identified, the object of Article 14 gets satisfied. Social, revenue, and economic consideration are certainly permissible parameters in classifying a particular group. Thus, a valid classification is nothing but a valid discrimination. That being the position, there can never be an injury to the concept of equality enshrined under the Constitution, not being an inflexible doctrine. But what it means is that supposing something has been done, which was not to be done in accordance with a particular laid down procedure or acceptable in law, it does not mean that if there is
benefit of equality is to be extended to the next group.
And Lord, the benefit of equality is based on exigencies of the situation. There are various facts, and if the facts establish that the first group who got the benefit was not properly, there was no proper extension of that benefit, then Lord, there is no discrimination. They are differently classified. These groups who have not been extended, they are differently classified. The benefit which has gone, that has been gone. In fact, they have not been affected. They could have been affected, but they have not been affected by garden reach, because whatever process has undergone has undergone. They don't want to open up, Lord, what has happened. But that does not mean that it should continue forever. That is what is supported, Lord, from this judgment. Your Lordships may kindly see paragraph 16, which is quoted. A larger latitude in dealing with challenge to the classification is mandated on the part of the court when introduced either by legislature or executive, as the case may be. There is no way courts could act like appellate authorities, especially when a classification is introduced by way of policy decision, clearly identifying the group of beneficiaries by analyzing the relevant materials. The question as to whether a classification is reasonable or not is to be answered on the touchstone of reasonable common man's approach, keeping in mind the avowed object behind it. If the right to equality is to be termed as genus, a right to non-discrimination becomes a species. When the two identified groups are not equal, certainly they cannot be treated as homogeneous group. A reasonable classification thus certainly would not injure the equality enshrined under Article 14, when there exists an inalienable differential between the two groups having a rational relation to the object. Then, Lord, please come to paragraph 25. This court cannot interfere with the policy decision taken by the government merely because it feels that another decision would have been fairer or wiser, as held by this court in the state of MP versus Narmada Bachao, etc., and relied upon and reaffirmed in Sudhir Budakatu. For these reasons discussed above, appeal is allowed. So, my Lord, what is happening is, Lord, if your Lordships looks at the decision in that Constitution Bench judgment, there they say that if you give appointment through a process which is not approved by your recruitment rules, you violate Article 14 and 16, because you violate the right of the persons who could have applied if there was an employment notification or there was a recruitment rules framing eligibility criteria, etc. So, my Lord, here today what has happened is, whatever happened for the purpose of, not for the purpose of temporary, my Lord, appointment, but Lord, subsequently whatever has happened, that has happened in violation of Article 14. Because if your Lordships look at Uma Devi's judgment, your Lordships will find that, Lord, the Constitution Bench clearly says that you cannot curtail the rights of the others. If there is a public employment, there has to be a notification for public employment, not for the temporary appointment. I am not talking about the advertisement for temporary appointment, because, Lord, that is not in aid of the 2006, Lord, the policy for compassionate appointment. It was an open advertisement for recruitment given to very many people who had also applied along with these persons, and this is for a temporary appointment for a temporary period. But Lord, later on what happened, that really, Lord, triggered a red flag so far as the government is concerned. That is how, Lord, the 2013 policy came to be framed. So, Lord, what is being said, that when you challenge a policy decision, here, Lord, the policy decision of 2013 is not under challenge in the writ. There is no writ of mandamus directing that the policy should be struck down. That is not there. But they are saying that you stick to 2006 policy, which is honest, and you give us appointment on the basis of whatever procedure was followed in 2006, according to 2006 policy.
Now, if 2013 policy is not under challenge, then the ratio of 2021 5 and 2023 14 will apply. Because if it is a mere prayer for granting benefits in terms of 2006 without laying challenge
it does
on
not
2013 policy.
Correct. It does not talk about 2006. Your Lordship will kindly see the prayers once again.
Yes, yes, that I remember.
Your Lordship will
Last
come.
question, you took me to this
Yes,
prayer.
because
give appointment.
The reason why I took your Lordship to the prayers is to show your Lordship that it is they are not asking for a writ of mandamus that in terms of 2006 you direct us to be appointed. So, my Lord, today, if at all, Lord, there is no challenge to the policy of 2013. 2013 policy stands. There can't be any two opinion about it. Conclude.
Yes, next judgment.
Lord, the next judgment, this is, Lord, all that I have to cite, Lord, on a question of policy decision. The next topic is that, Lord, yes, the next topic is that, Lord, if rules are absent, say for example here recruitment rules were absent. So, Lord, administrative instructions were given that you frame a policy for death in harness and also frame up recruitment rules. So, Lord, this is well within the power of the executive. That, Lord, to say that you have to frame a recruitment rules before you proceed to recruit either on direct recruitment basis or on death in harness basis. So, Lord, this is a judgment which is reported in 2025, volume 2 SCC, page 1.
Page Prakash. Yes.
Yes. Lord, directly come to paragraph 13. There was a reference to the because Mr. Mojumdar also took a point. Yes, that is the reason, Lord, I'm dealing with it. Lord, I'll deal with his point, Lord, in the process. Please come to, Lord, paragraph 13.
Yes.
Public service broadly fall into two categories. One, where services are in connection with affairs of the state union. Secondly, where services are under instrumentalities of the state. In either category, law governing recruitment must conform to the overarching principles enshrined in Article 14 and 16 of the Constitution. In various judicial pronouncements, the law governing recruitment to public service has been colloquially termed as the rules of the game. The game is the process of selection and appointment. Courts have consistently frowned upon tinkering with the rules of the game once the recruitment process commences. This has crystallized into an oft-quoted legal phrase that rule of the game must not be changed midway or after the game has been played. Broadly speaking, these rules fall in two categories. One, which prescribes the eligibility criteria, essential qualification of the candidate seeking employment, and the other, which stipulates the method and manner of making the selection from amongst the eligible candidates. Then, Lord, please come to 16. The law is settled that after commencement of the recruitment process, the eligibility criteria is not to be altered because candidates, even if eligible under the altered criteria, might not apply by the last date under the belief that they are not eligible as per the advertised criteria. Such alteration change therefore deprives a person of the guarantee of equal opportunity in the matter of public employment provided by Article 16 of the Constitution. The reference order therefore acknowledges this legal position and in clear terms accepts the rule of the game cannot be changed after commencement of the recruitment process insofar as eligibility criteria is concerned. However, in regard to changing the rules of the game qua Method of procedure for selection, the three-judge bench of the reference order doubted the correctness of the decision of K. Manjushree, inter alia on the ground that it failed to notice an earlier decision of Subhash Chandra Marwah. Accordingly, the reference order seeks an authoritative pronouncement in that regard from a larger bench of this court. The scope of the reference is therefore limited to A, whether K. Manjushree lays down the correct law, B, whether the rules of the game, method and manner of making selection can be changed. Now, Lord, your Lordships may kindly straight away come to paragraph 21. Come to 22. The process of recruitment
Yes.
The process of recruitment begins with the issuance of advertisement and ends with the filling up of notified vacancies. It consists of various steps like inviting applications, scrutiny of application, rejection of defective applications, or elimination of ineligible candidates, conducting examination, calling for interview or viva voce, and preparation of list of successful candidates for appointment. Now, Lord, I just pause here for a moment. Your Lordship has seen the advertisement. The advertisement was for recruitment of a set of people as casual workers, purely on casual basis. It was not an employment advertisement for recruitment of the die in harness category of cases. It was basically for temporary appointment. And Lord, considering the past situation, the central government interfered and Lord stopped that. Now, your Lordships may kindly come to paragraph 22, your Lordships has seen. Then, Lord, please come to paragraph 26, which deals with legitimate expectation. However, doctrine of legitimate expectation does not impede or hinder the power of public authorities to lay down a policy or withdraw it. This is the dissenting view which is coming in the answer to the reference. The public authority has the discretion to exercise the full range of choices available with its executive power. The public authority often has to take into consideration diverse factors, concerns, and interest of before arriving at a particular policy decision. The courts are generally cautious in interfering with a bona fide decision of public authorities which denies legitimate expectation provided such a decision is taken in the larger public interest. Thus, public interest serves as a limitation on the application of the doctrine of legitimate expectation. Now, let I just pause here for a moment. Even it is assumed that those advertisements gave them a legitimate expectation that they will be recruited in as a temporary workers or employees.
Yes.
Government can still change the policy. They're not it's not bound by the advertisement if it feels that it is in greater public interest. Now, if these people were recruited as temporary hands and then converted into a permanent employee, it would have gone against the public interest, because that would directly hit what the Constitution bench has decided. So, this is what it says, that the courts are generally cautious in interfering with the bona fide decision of public authorities which denies legitimate expectation provided such a decision is taken in the larger part.
Mr. Kaur, this appointment on compassionate ground is an exception. Exception to the general.
Correct.
Whether the concept or the ratio of stage focus will squarely apply.
Lord, I am citing this
because this is I have read this judgment. This is for recruitment in connection with the posts for under open category.
Absolutely, that would have been my submission, because Mr. Majumdar has relied upon the judgment. I am trying to deal with the judgment because this comes at a point of time where here, in fact, this negates the case that Mr.
Because the recruitment process has been divided into two parts. First part is eligibility, criteria and whether this can be changed after initiation of process? Answer is no. And the second part is selection and appointment from the from the final panel, where there are certain observations made by the Honorable Supreme Court. But the entire process is concerning posts which are meant for open category candidates.
Absolutely. Your Lordship is right. Lord, what had happened here is the advertisement which is issued, that is not in respect of any substantive posts. These are only, Lord, for recruitment as a temporary measure. And considering the past situation, Lord, the government intervened and directed that you change the policy. The policy is that if you want to give compassionate appointment, you must stick to certain guidelines, which is the guideline of the DOPT as well as the guideline of the Goa shipyard. But so far as open category is concerned, you frame recruitment rules. That is how the recruitment rules came to be in existence. So, my lord, I am saying that at a situation when this decision was taken by the government, this decision was taken in public interest. Today, my lord, the fact my learned friends are concerned about their appointment under the compassionate appointment category. There was no initiation of employment under the compassionate appointment category. Therefore, my lord, there can't be any legitimate expectation also. I am trying to, my lord, deal with this judgment because Mr.
Considering the nature of advertisement in 2006,
absolutely,
it was meant for open category candidates. This is your contention.
This is my category. This is my contention. You go open category, and Lord, that open category was also not properly made without a recruitment rules. Therefore, Lord, the government stepped in and said that you frame your recruitment rules first, which was then framed. In 2013, both were framed. The recruitment rules was framed as well as, Lord, the policy was framed. This is the reason why I am really, Lord, citing this. And your lordships may kindly see just one more paragraph in this context. This is, Lord, kindly come to paragraph 44. 44 and 65. These two paragraphs, Lord, kindly take note of.
Initiation of selection process should be based on the eligibility criteria.
Absolutely.
But appointment, there the authority can take a decision that what to be appointed on.
Yes.
That is the crux of this.
The crux of the matter. But here, neither the eligibility criteria is fixed, nor, Lord, the recruitment rules are there. So, Lord, that is the reason why the government says that how can you proceed?
Yes, paragraph 44.
44.
Yes.
I'm sorry, paragraph 49.
49.
Yes.
Just.
Sometimes I can't read my own handwriting.
It also happens to me. Yes.
Kindly, Lord, come to 49. The ultimate object of any process of selection for entry into public service is to secure the best and the most suitable person for the job, avoiding patronage and favoritism. Selection based on merit tested impartially and objectively is the essential foundation of any useful and efficient public service. So, open competitive examination has come to be the accepted almost universally as the gateway to public service. It is now well settled that while a written examination, etc. Then, Lord, please come to paragraph 65. Just one more paragraph.
Paragraph?
Paragraph 65. The conclusion.
65. Yes, just.
Or rather, my lord, kindly see 63 and 64 also.
Yes.
On a question of legal right, these are the two paragraphs, my lord, on which I rely. In section C above, we have already noticed the constitution bench decision in the court of Shankarshan Dash, where it was held, unless the relevant recruitment rules so indicate, the state is under no legal duty to fill up all or any of the vacancies. However, it does not mean that the state has the license of acting in the arbitrary manner. The decision not to fill up the vacancies has to be taken bona fide for appropriate reason. And if the vacancies or any of them are filled up, state is bound to respect the competitive merit of the candidates as reflected at the recruitment test, and no discrimination can be permitted. Thus, in the light of decision in Shankarshan Dash, a candidate placed in the select list gets no indefeasible right to be appointed even if vacancies are available. Similar was the view of this court. The insistent harping of the fact that March 2006 was the cutoff date where certain persons were selected or brought under a list. Lord, that does not give them a legal right to seek mandamus, and that too in implementation of a scheme which is not there. This is the reason, Lord, why I read this paragraph. 65.4, 65 is the conclusion.
Yes.
65.4 may kindly be taken note of. It says recruiting bodies subject to the extant rules may devise appropriate procedure for bringing the recruitment process to its logical end, provided the procedure so adapted is transparent, non-discriminatory, non-arbitrary, and has a rational nexus to the objects sought to be achieved. The 5% reservation in the quota.
Yes.
That you can't exceed 5%, because then you eat into the general category quota or OBC or other persons who are directly going to compete and come into the post. Now, my lord,
that 5% was introduced in 2013 scheme.
2013 scheme. Following the DOPT guideline and
Yes.
Goa shipyard.
Yes. Then
no, it was not there in 2006. That is what he says. Lord, the last next is Lord. না তুমি আগে এইটা ডিল করি, কম্প্যাশনেট অ্যাপয়েন্টমেন্ট গুলো ডিল করি। তোমার টিঙ্কুটা আগে দেখাবো, আর্টিকেল 14টা নেগেটিভ ইকুয়ালিটি। আচ্ছা, এটা নিয়ে যাবেন না, শুধু এটাই দেখাবেন না? এটাই দেখাই, একটাই দেখাই। Negative on the question of
compassionate appointment issue, it should judgments are to be placed according to the decision of Mr. Dey.
Absolutely. My lord has saved me. Lord, on negative equality, that's the next subject.
Yes.
Lord, my learned friend, Lord, has given me a list of cases. I just choose the last one.
Yes.
It is 2024 SCC online. SC 3292.
3292.
Yes.
Paragraph?
Lord, I'll just indicate, Lord, paragraph 9 to 15. Kindly give me 1 minute. আমার এখানে দাগ দেওয়া আছে 2024 SCC online. এর নামটা হচ্ছে টিঙ্কু, না? টিঙ্কু was state of very 229. Lord, kindly come to paragraph 9. না, please. খুঁজে পাচ্ছি না। That has you actually got paragraph
9. Yes.
That apart, the claim as has been stated above cannot be accepted being not supported with any statutory backing. This is required for making any claim, including a claim for compassionate appointment, which is an exception to the general rule of appointment requiring a proper advertisement and selection process to be followed as per rules, which is an accepted norms. If some wrong benefit has been conferred or some benefit which is contrary to the scheme has been granted, it would not bestow a right upon the others to claim it as a right of equality by reference to Article 14 of the Constitution of India. Then
Well settled principle.
Well settled principle.
Well settled. Mr. Kaur, you need not dilate on this issue.
Then kindly take note of, I'll not read. Kindly, my lord, take note of paragraph 12, 13, 12, 13, 12 to 16. Paragraph 14, Lord.
You want to place it?
No, this is, you'll kindly take note of. I mean, these are well settled principles. I need not, Lord.
Yes, yes.
Now, my lord, the main issue
Yes.
that the
in
constitutional
harness
bench,
study.
that those conflicting judgments, may I just, my lord, address your lordship on that? NC Santoshta aage dekhai. Lord, if your lordships kindly take justice this NC Santosh's case once. This is, my lord,
Yes, it is already there.
2020 volume 7. হ্যাঁ, আর দরকার নেই, আছে তো জজ
Yes.
সাহেবের কাছে দেওয়া আছে। Lord, first kindly see the facts from paragraph 1 and 2.
NC Santosh has also been relied upon by the petitioners
Justice,
in order to distinguish it.
yes, yes. Justice Dotto has subsequently also has relied upon, considered it. So, my lord, I'll just praise Santosh and then, my lord, because Santosh, my lord, considers, my lord, the earlier judgment.
Yes, yes.
So, if your lordship permits, my lord, just Santosh and then, my lord, the
Yes.
kindly take note of paragraph 1 and 2, because, my lord, this will be.
You are relying on from a reported judgment.
Yes, yes.
Give me a copy.
Yes, I'm sorry. This is, my lord, reported in 2020 volume 7, page 617.
617. Paragraph?
Paragraph, my lord, 1 and 2, first I rely, and then, my lord, paragraph 9 to 11 and 17 to 19.
Yes.
If your lordships, my lord, kindly take paragraph 1 and 2, these are the factual score. Leave granted, the appellants here were the beneficiaries of compassionate appointments. But on discovery that their appointments were made dehots the provisions of the Karnataka Civil Services, etc., as amended, etc., those appointments came to be cancelled. The amendment to the provisions of Rule 5 stipulated that in case a minor dependent of the deceased government employee, she must apply within 1 year from the date of death of the government servant, and he must have attained the age of 18 years on the date of making the application. Before amendment, the minor dependent was entitled to apply till 1 year of the attaining majority. When their services were terminated, the aggrieved appointees approached the Karnataka Administrative Tribunal at Bangalore, but the tribunal found that the appellants were ineligible for appointment under the rules and accordingly dismissed the related application. The resultant writ petitions were dismissed by the High Court of Karnataka at Bangalore, leading to the present appeal. So, my lord, basically change of rule, which was, my lord, the subject matter of consideration before the tribunal as well as the High Court. Now, my lord, please come to paragraph 9.
Yes.
Lord, paragraph 8 talks about the unamended rule and the amendment. Your lordships may kindly take note of. I'm not reading. This is paragraph 8 talks about the first the unamended rule and then, Lord, the amended rules. 9. While Rule 5, as it's originally stood, enabled a minor dependent to apply within 1 year after attaining majority, the rulemaking authority with the amendment affected from 1499 stipulated an outer limit of 1 year from the date of death of the government servant for making application for compassionate appointment. The validity of the amended rules is not challenged in any of the present proceedings. Following the amendment, the norms clearly suggest that the earlier provisions which enabled a minor dependent to apply on attaining majority, maybe years after the death of the government servant, has been done away with. The object of the amended provision is to ensure that no application is filed beyond 1 year of the death of the government employee. The consequence of prohibiting application by a minor beyond 1 year from the date of death of the parent can only mean that the appellants were undeserving beneficiaries of the compassionate appointment as they attained majority well beyond 1 year of the death of their respective parents. Then, Lord, paragraph 10 and 11 in these cases, when the government employee died, the appellants were minor and they had turned 18, well beyond 1 year of the death of the parent. As can be seen from the details of the chart, the dependents attained a majority after a gap of 2 to 6 years from the respective date of death of the parents. By the time the dependent children turned 18, the amended provisions became operational with effect from 1/4/1999. As such, their belated application for compassionate appointment should have been rejected at the threshold as being not in conformity with the proviso to Rule 5. The appellant applied for compassionate appointment after attainment of majority well beyond the stipulated period of 1 year from the date of death of the parent, and therefore those applications should not have been entertained, being in contravention of the rules. Then, Lord, the 1996 rules, it says that it was considered, Lord, in the earlier judgment. And then your lordships may can kindly skip paragraph 11, come to paragraph 17 to 19. This is where Lord Mahesh Kumar
was considered.
Yes. The above discussion suggests that in the view taken in Canara Bank versus Mahesh Kumar is to be reconciled with the contrary view of the coordinate bench in the two earlier judgments. Therefore, notwithstanding the strong reliance placed by the appellant's counsel on Canara Bank versus Mahesh Kumar, as also the opinion of the learned single judge of the Karnataka High Court in such and such, it cannot be said that the appellant's claim should be considered under the unamended provisions of the rules prevailing on the date of death of the government employee. In the most recent judgment in state of so and so, the earlier decisions governing the principles of compassionate appointment were discussed and analyzed. Speaking for the bench, Justice Chandrachud reiterated that the appointment to any public post in the service of the state has to be made on the basis of the principles in accordance with Article 14 and 16 of the Constitution, and compassionate appointment is an exception to the general rule. The dependents of the deceased government employee are made eligible by virtue of the policy on compassionate appointment, and they must fulfill the norms laid down by the state's policy. Applying the law governing compassionate appointment culled out from the above judgment, our opinion on the point at issue is that norms prevailing on the date of the consideration of the application should be the basis for consideration of claim of compassionate appointment. A dependent of the government employee, in the absence of any vested right accruing on the death of the government employee, can only demand consideration of her application. He is, however, disentitled to seek consideration in accordance with the norms as applicable on the day of the death of the government employee. So, my lord, basically, it says that the policy will govern. The policy would govern. Basically, the summary of the judgment is the policy would govern. So, if there is a change in the policy, that change policy has to be applied in the case of consideration.
Yes.
Now, my lord, this view and this view, I'm Lord, after this, Lord, before I go to Justice Dotto's judgment, Lord, I would like to show, Lord, another judgment which is reported in, Lord, in 2023 SCC online SC 219. This is on the question of immediacy.
Just a minute. SCC online SC page
page 2119.
Paragraph
Lord, 28, 29, and then Lord 33 to 35, and 45 and 46. এটা হচ্ছে কোনটা জানো?
Yes.
দেবব্রত। দেবব্রত, হ্যাঁ, 97. But kindly give me 1 minute.
Yes.
Kindly give me 1 minute.
Yes, yes.
Lord, please come to paragraph 28 and 29. 28 first. Points for consideration. Its first question is whether the revision bench of the High Court at Kolkata erred in allowing the appeals filed by the respondent writ petitioner and directing that their claim for compassionate appointment be considered by the appellate. Then what order? Then these appeals are primarily concern the question whether there exists any scheme in the state of West Bengal governing compassionate appointment governing municipal employees dying in the harness. In the event that the aforesaid question is answered in the affirmative, it would be necessary to determine whether a direction issued several years after the application for compassionate appointment are filed to consider and decide such application is in consonance with the object of a policy scheme or compassionate appointment. Then, Lord, the scheme and other things are discussed. The Lordships may kindly come to paragraph 33. The object underlying a provision for grant of compassionate employment is to enable the family of the deceased employee to tide over the sudden crisis due to the death of the bread earner, which has left the family in penury and without any means of livelihood. Out of pure humanitarian consideration and having regard to the fact that unless some source of livelihood is provided, the family would not be in a position to make both ends meet, a provision is made for giving gainful appointment to one of the dependents of the deceased who may be eligible for such appointment. Having regard to such an object, it would be of no avail to grant compassionate appointment to the dependents of the deceased employee after the crisis which arose on the account of death of a breadwinner has been overcome. Thus, there is also a compelling need to act with a sense of immediacy in the matter of concerning compassionate appointment, because on failure to do so, the object of the scheme of compassionate would be frustrated. Where a long lapse of time has occurred since the date of death of the deceased employee, the sense of immediacy for seeking compassionate appointment would cease to exist and thus lose its significance, and this would be a relevant circumstances which must weigh with the authorities in determining as to whether a case for the grant of compassionate appointment has been made out for consideration. As noted above, the sine qua non for entertaining a claim for compassionate appointment is that the family of the deceased employee would be unable to make two ends meet without one of the dependents of the deceased employee being employed on the compassionate ground. The financial condition of the family of the deceased at the time of death of the deceased is the primary consideration that ought to guide the authority's decision in the matter. Considering the second question referred to above, in the first instance, regarding whether applications for compassionate appointment could be considered after a delay of several years, we are of the view that in a case where, for reasons of prolonged delay, either on the part of the applicant in claiming compassionate appointment or the authorities in deciding such a claim, the sense of immediacy is diluted and lost. Further, the financial circumstances of the family of the deceased may have changed for the better since the time of the death of the government employee. In such circumstances, court or the other relevant authorities are to be guided by the fact that for such prolonged period of delay, the family of the deceased was able to sustain themselves, most probably by availing gainful employment from some other sources. Granting compassionate appointment in such a case, as noted by this court in Hakim Singh, would amount to treating a claim for compassionate appointment as though it were a matter of inheritance based on a line of succession which is contrary to the constitution. Since compassionate appointment is not a vested right and the same is relative to the financial condition and hardship faced by the dependents and the deceased government employee as a consequence of his death, a claim for compassionate appointment may not be entertained after lapse of considerable period of time since the death of the government employee. Then, Lord, please take note of paragraph 45 and 46.
Yes.
Lord, your lordships will find the dates here, just for the dates that your lordships might kindly come to paragraph 45. My lord will find the applicants for compassionate appointment were made in the year 2005-6. Admittedly, the first concrete step taken by the chairman Badwan municipality was in the year 2013, when the said authority forwarded a list of candidates to be approved by the director of local body, Badwan municipality. The respondent writ petitioners knocked on the doors of the High Court at Calcutta only in the year 2015, after lapse of nearly 10 years from the date of making of the application for compassionate appointment. The respondent writ petitioners were not prudent enough. Then, Lord, the sense of immediacy, paragraph 46. In the matter of compassionate appointment has been lost in the present case. This is attributable to the authorities of the appellate state as well as respondent writ petitioner now entertaining a claim of 2005 and 6 would be of no avail.
But here, Mr. Court, petitioners are repeatedly coming.
Yes, Lord, what Lord, in my closing submission, I'll make that an issue. Lord, what have they done? Lord, they had filed an earlier writ petition. The earlier writ petition direction was that take steps in accordance with law. There was no direction that 2006 should be implemented.
Yes, in 2009, within a period of 6 months.
In 2009, they said it takes steps in accordance.
In 2008, this was a panel was prepared. Now in 2009, when CVC raised objection, then writ petition was filed.
Writ petition was filed, and that writ petition disposed of by saying that you take steps in accordance with law. Now, Lord,
within a particular time.
Within a period
with the presence of the CVC,
yes,
against which GRAC preferred an appeal.
CVC preferred an
appeal. preferred an appeal. 13
CVC preferred an appeal.
CVC preferred an appeal. 13 March 2013 order, where the division bench directed only extended time for a period of 6 months
and said
directed the represent and responsible officer of CVC to remain present.
Lord, what I'm on is that even at that stage,
in the present case, Mr. Kaur, which you are relying upon, that is 2013 SCC online, the approach was made in 2013.
That is on the part of the petitioner. But there were delays, Lord, innumerable delay, Lord, on the part of the authorities also, because 2005-6 the application was made. This was forwarded only in 2013. So, Lord, delay. What I'm saying, my submission is that this is on the ground of immediacy. That immediacy is lost. Lord, whether it is delay on the part of the petitioner or on the part of the respondent authorities is immaterial. But the question is whether the immediacy remains.
But Mr. Kaur, if after the date, if there is no time delay on the part of the applicant in approaching the authority, and thereafter due to the decisions taken one after another or delay on the part of the authority, why the applicant would be penalized?
Lord, it is not a question of penalizing. Lord, what this judgment says is due to
immediacy,
loss of immediacy, the situation changes, the equation changes. There may be a better, Lord, life.
You will get answer in Ajit Kumar's case, where Justice Dotto has considered this delay.
Sir, I'll come to Ajit Kumar because I definitely, Lord, thought, Lord, I'll take Ajit Kumar last because this Ajit.
All the judgments are considered.
Yes. I don't think this was considered. This judgment.
But the delay part was considered.
Yes, I'll deal with that aspect. I'll deal with that. Now, Lord, I straight away come to Justice Dotto's, Lord, judgment. That is, Lord, Canara Bank, second Canara Bank. Lord, that is reported in 2025 SCC online.
Yes.
SC 290.
That already, this is not from SCC. SCC is 2025 SCC online 290. It is there. So
yes.
Therefore, it will tally.
Yes.
Yes. So you are relying upon.
Lord, just give me 1 minute.
Yes.
এটা কোথায় আছে লাস্টের
আমাদের লিস্টে লাস্টের
এটা কোথায় দেবব্রত তিওয়ারি
আপনি দেখালেন
হ্যাঁ এটা হলো দিল্লি ক্লক
দিল্লিতে তো বলতেন দেখান
এখানে আছে তাহলে আর একটা দুটো কেস ছেড়ে গেছে 2025 এসসিসি অনলাইন 290 আচ্ছা Lord, kindly come to paragraph 1 and 2, Lord, states the facts. Your Lordship can kindly take note of.
Yes.
Then, Lord, please come to paragraph 14.
করে দেওয়া ভালো ওটা আমাদের এগেনস্ট 18th
Lord, your lordships may kindly come to paragraph 14. Lord, these are the cases that your lordships can, Lord, up to paragraph 17, Lord, that the NC Santosh is considered. Yes. I don't think I'll waste your lordship's time on that. Please straight away come to paragraph 23. All the earlier judgments are considered. Please come to paragraph.
Paragraph 23.
The judgment that I cited before your lordships, this Justice Nagratna's judgment, that was not cited before my lord. That I think was not cited. Please come to paragraph 23. Since Canara Bank has been referred to larger bench and the larger bench is yet to give its decision, learned counsel for the appellant was heard to submit that we ought to wait such decision. However, we can brook no further delay, having regard to the lapse of time, since the judgment was reserved on this appeal, because the decision of the larger bench is not in sight, and most importantly, the respondent is waiting for more than 2 decades, not knowing what destiny has in store for him. So, my lord, the learned judge, my lord, proceeds to decide the matter. Then please come to paragraph 32. ওই ডিলের ইয়েটা কোথায় আছে? ডিলের ডিসকাশনটা কোথায় আছে? Lord, this takes note of the order of the MD. Your lordship can. Has your lordship got the judgment?
Yes, yes. Paragraph.
Paragraph 32. The order of the MD, second sentence. Your lordships may kindly. The order of the MD and CEO has been extracted above verbatim. What transpires from a bare reading of such an order is that the deceased left behind him his widow, his respondent, and 3 daughters as his surviving heirs. All the daughters were married and settled. Only his spouse and son could not count as dependent. Could count as dependent. The daughters were not shown to be dependent on the deceased while he was alive and in service. The respondent and his mother were residing in their own house. That apart, the deceased has 4 months away from retirement on the superannuation. It has been indicated in such order what the last drawn salary of the deceased was, and had he survived even after superannuation, what quantum of money would have he received as monthly pension. Also, the amount of monthly family pension being paid to the respondent's mother is indicated. Although on behalf of the respondent, a contention has been raised that there has been no proper assessment of his financial condition. Rather strangely, the figure referred to by MD and CEO have not been disputed at all. We are thus left with no option but to proceed on the basis that the same are correct. If indeed the respondent's father would have received a pension amount of such and burden to feed himself as well as his 2 dependents, his spouse and son, the amount of family pension initially sanctioned could not have by any stretch of imagination be seen as sufficient, insufficient or inadequate for the feeding of 2 mouths. It is also not in dispute that the net terminal benefits in a sum of rupees such and such, etc. Look, this is a detailed exercise which the court had gone into. This exercise was done as to the date of retirement, how much he received, what was the pension amount, how much would have been sufficient for the families, how many members, etc. This exercise is not there. Insofar as we are concerned, this exercise is not there. In fact, apart from the fact of date of death, Lord, I don't think, Lord, and Lord, the exercise that has been done is with regard to the income certificate that has been given by the local MLAs or Lord, the union in some case. And Lord, that income certificate shows that there are sufficient income, and that has been taken note of by the authority. But Lord, I'm not really troubling your lordships on this. Yes, Lord, the delay part is, I think, paragraph 27. Your Lordships may kindly come back to 27.1. Kindly, my Lord, come to paragraph 27. The lapse of time could, however, be a major factor for denying compassionate appointment where the claim is lodged belatedly. A presumption is legitimately drawn in cases of claims lodged belatedly that the family of the deceased incapacitated employee is not in immediate need of financial assistance. However, what would be a reasonable time would largely depend on the policy scheme for the compassionate appointment under consideration. If any time limit has been prescribed for making an application and the claimant applies within such period, lapse of time cannot be assigned as a ground for rejection. This is what, Lord, makes the judgment distinctive with the earlier judgment. Here, the only the additional feature of this judgment is if the scheme provides that, Lord, application has to be made within a particular time,
Yes.
and the applications are made within that time, then, Lord, delay will not apply.
Yes.
This is the only, Lord, modification, I would say, of the view that is expressed not in the that Devabrata
Is it a
theory.
case where the applicants did not approach the authority within time?
After the date, gap is huge.
Lord, I believe, Lord, the gap between the date of death and the application are large. In fact, in most of the cases that there are a lot of lapses. But 2006 scheme did not contain a clause like this. 2006 scheme did not contain a clause like this. So therefore, Lord, it became an open-ended situation.
And nowhere petitioner's case was rejected that since petitioners approached the authority not within time.
Lord, the rejection aspect
that is only on the point of indigence.
Correct. Lord, if your Lordships kindly sees a chart note at page 625 once. Lord, I'll just come back to the judgment if your Lordship kindly.
No, first place the judgment.
Lord, please come to paragraph 35.
Paragraph 35.
Yes. Kindly come to 35. However, the point having been argued at some length.
Mr. Kaur, prior to that, please read paragraph 26.
26. Yes. More often than not, earned claims for compassionate appointment reach the High Courts or even this court after consuming substantial time. The ordinary rule of litigation is that the right to relief should be decided by reference to the date on which the suitor entered the portals of the court. The relief that the suitor is entitled to in law could still be denied in equity on account of subsequent and intervening events. Events between the date of commencement of the litigation and the date of decision. However, law is well settled that such relief may not be denied solely on account of time lost in prosecuting the proceedings in judicial and quasi-judicial forum for no fault of the suitor. It would therefore not be prudent or wise to reject a claim only because the time taken by the courts to decide the issue before it. Accept it. Lord, if the matter is pending in court, then, Lord, it can't be said that there is a delay on either side.
Yes.
But, Lord, the question of Justice Nagaratna decided, Lord, is something different. Justice Nagaratna says that first there is a delay either on the part of the parties, either party, the party in applying or, Lord, respondents in processing it or rejecting it. If the situation changes in between, then that situation will govern. That is what Justice Nagaratna's judgment.
But Mr. Or one thing, if there is a scheme which says within 6 months you apply, it is applied within 6 months.
Then it's
if authority takes decision,
then it's
after 5 years.
No, then that's a changed situation. That is not taken note of in Justice Nagaratna's judgment. That is taken note of in Justice Doctor's judgment. Your Lordship is absolutely right. Justice Doctor takes note of two situations. One is that if the scheme provides a time limit and a person applies within that time limit, there can be no delay attributable. Number one. And he also says that if the court proceedings take unusually long time, then no delay can be attributable to the parties.
Therefore, this on the point of delay, if within time it is not applied, then straightway the claim of the petitioner can be rejected solely on the point of delay. But nowhere the authority has taken a decision spurning the claim of the petitioner on the point of delay.
Lord, I am harping on this point only to show that this point of immediacy was introduced in the 2013 scheme, which was not there in 2006 scheme. Lord, 2013 scheme, which was formulated, there, Lord, this immediacy was introduced. So, Lord, what I intend to tell your Lordship is this, that, Lord, parties can't be tardy. They have to, Lord, be more, Lord, agile to the fact that I have to take action within a particular time. Lord, this is the only reason why I dealt with this decision. And here, Lord, again, Lord, the Justice Dr. Lord reiterated that the existing rule should be applied. This is the other reason, Lord, why I thought, Lord, I'll place it.
Place it according to your own.
Lord, please take, Lord, paragraph 44, 45.
Yes.
47 and 48. 44, Lord, I place first. As pertinently held in B. Kishore, indigence of the dependents of the deceased employee is the fundamental condition to be satisfied under any scheme for appointment on compassionate ground, and that if such indigence is not proved, grant of relief in furtherance of protective discrimination would result in a sort of reservation for the dependents of the employees dying in harness, thereby directly conflicting the ideal of equality guaranteed under Article 14 and 16 of the Constitution. Also, judicial decisions abound that in deciding a claim for appointment on compassionate grounds, the financial situation of the deceased employee family must be assessed. In a situation otherwise, the purpose of the scheme may be undermined. Without this evaluation, any dependent of an employee who dies while in service might claim a right to employment as if it is heritable.
Yes.
The ratio decidendi of all these decisions have to be read in harmony to achieve the noble goal of giving succor to the dependent of the employee dying in harness who are genuinely in need, and not with the aim of giving them a post of another for another post. One has to remember in this connection the caution sounded in Umesh Kumar Nagpal that as against the destitute family of the deceased, there are millions of other families which are equally, if not more. Then 47. At the same time, we cannot be oblivious of Canara Bank Supra having been rendered by a coordinate bench, having disagreed with Canara Bank Supra. Judicial propriety demands that we follow the appropriate course to refer the matter to a larger bench. We are also not oblivious of the legal position that so long the decision that is doubted is overruled, it continues to remain binding. A reference to a larger bench as made by the coordinate bench in Shiv Shankar Tiwari, if made by us, would only add to the agony and pain of the respondent, considering that one cannot foresee an imminent resolution of the controversy. In the light of the admitted fact that the reference made by Shiv Shankar Tiwari in 2009 is still unanswered. Having regard to the foregoing discussions, the predicament faced by the High Court, we cannot hold the impugned order to be entirely unjustified. To the extent it has relied on Canara Bank Supra, we cannot fault the division bench, or for that matter, the single bench. The division bench, feeling bound by Canara Bank Supra, did not have the occasion to enter into a proper examination of the order of the MD and CEO. It was of the clear impression that the said order was in the teeth of what was held in paragraph 19 of this court in Canara Bank. However, at the same time, we are of the firm opinion that notwithstanding Canara Bank, the division bench ought not to have overlooked the criteria relating to suitability while directing appointment of the respondent straight away. To this extent, the learned counsel for the appellant is right, and that the question of suitability was left untouched by the Canara Bank, and the appellant ought not to have been made to suffer an order of its appeal having more adverse consequences than the order on the writ petition. In the fitness of things, we decide to invoke our powers under Article 142. That's separate. Now, my lord, there are a couple of things which should be, my lord, looked into in vis-a-vis the judgments. Lord, the first is, I just, Lord, summarize my submission. The 2006 policy, this was, Lord, had a cutoff date of 31st March 2006. Now, Lord, the contention of the central government was that this is not a scheme framed according to law. And there was a further charge that this scheme was not signed by authorized person. This was not framed by the authorized person. The board did not approve it, and the managing director also did not give approval. On the contrary, the earlier board meetings would show that there was a clear direction by the board that you frame the policy in line with the similar enterprises. Now, Lord, 4 advertisements are issued. These advertisements are not based on the 2006 policy, because these advertisements or employment notice is not for recruitment under compassionate appointment. These are advertisement, Lord, for casual employment, purely temporary, for day-to-day requirement. Now, Lord, preference to this gave preference to the eligible dependents subject to merit being equal. So, Lord, there is no compassionate appointment. They are not considered per se. They are considered along with the general candidates. The merit being equal, they will be considered, they will be giving preference for the purpose of temporary or casual employment. This action was not pursuant to 2006 scheme, because your lordships will find in 2006 scheme, this was not the modus. This was not the modus at all agreed to. Now, about 226 people got employment out of this 3 sets of advertisements which went through. Out of this 226, 170 were, Lord, the persons who stated to have been the under compassionate category, but they were obviously not considered as with the general candidates. Now, after 170 having gone through, there were certain leftovers in that list, because 279 employees were shortlisted. That's their case. Now, Lord, 170 minus 279 brings it down to 109. This writ petition has been filed by 49, and out of which the papers were given 30 by 30. Now, Lord, the these 170, along with the others, 220, 226 roughly, they were all given employment. Made permanent without there being a subsequent employment notification. Now, Lord, at this stage, the central government, Lord, they really, Lord, they woke up. The vigilance, Lord, gave certain notice, etc. And ultimately, my lord, there is a detailed loopholes, Lord, pointed out by the central government. This, Lord, I have already placed from page 38 to 41 of the additional document of GRSC. As on that date, when, Lord, these 4 advertisements were issued, there were no recruitment rules of the company. According to the advertisement, the last advertisement, there are about, for 105 posts, there are about 4,278 applications received. They are all, Lord, to be compared and considered along with the general candidate for merit and, Lord, for absorption or for appointment on temporary basis. Now, Lord, this is the stage when, Lord, this application was filed for enforcement of their right for compassionate appointment. Lord, as regards the compassionate appointment, there was no notification, neither there was any invitation for compassionate appointment. Now, Lord, the writ petition, there is an order of Justice Topenchin which says that start the process of consideration subject to eligibility and other requirements in accordance with law. This is clear, Lord, observation. The GRSC did not prefer an appeal, but, Lord, the central government did. And on that basis, the division bench order, the appeal was dismissed. And, Lord, I've completed.
Oh,
just
yes,
5 minutes. 5 minutes.
Yes.
The appeal was dismissed, but direction was that complete the process of consideration by 6 months in accordance with law. Process of consideration by 6 months in accordance with law. Now, Lord, the policy of compassionate appointment came around this time in 2013. In fact, order of the division bench is dated 13th March 2013, and, Lord, the policy for compassionate appointment was framed on 27th of August 2013. But before that, there was a series of correspondence from 2009, where, Lord, GRSC was asked to frame their policy and rules according to the guidelines. Then, Lord, division bench order in contempt, where, Lord, the consideration of these candidates were placed on record by an affidavit. Your Lordship,
division bench said it was not a contempt.
there was no contempt.
There was no willful violation.
Your Lordships will find, Lord, details of consideration, Lord, in volume 1 from 250 page 255.
Chellu's judgment order, the division bench presided by Justice Chellu.
Yes. Now, Lord, in the writ, Lord, I also say that the report of the committee has not been assailed, because, Lord, your Lordships will find the division bench said that you can assail the report of the committee in the writ petition. The report of the committee is not assailed. Your Lordships will find that observation. It says that assail the decision of the committee. It has not been assailed. Now, Lord, today the question is in the second writ petition, which policy to be followed? Can we follow the 2013 policy, which is not, 2006 policy, which is not in existence? Number one. Number two, that 2006 policy was never given effect to, because all these advertisements are not in pursuant of the 2006 policies. These advertisements are independent of those the 2006 policy, where temporary recruitments are made, and, Lord, then they are made permanent. This is what is objected to by the central government. And central government says that you can't do it because you have to first frame a recruitment rules and also frame a proper policy, not the policy of 2006. So this is the stage we are. My humble submission is that 2013 policy was rightly applied pursuant to the division bench judgment, and, Lord, there is a finding given by the committee. I wouldn't say that there is a finding. The committee has given its factual finding that these persons are surviving despite the passage of time, and their earning, which they did not submit in terms of the 2013 scheme. The earning certificate has to be given by a revenue authority in terms of 2013 scheme. They have not submitted their income certificate in terms of the 2013 scheme. So their income certificate that they have submitted, taking that into consideration, the facts has been placed before the division bench by a tabular statement that they are surviving, that there has been a passage of time, and Lord, the test of compassionate appointment with immediacy and other things, that period has crossed. So this is the stage at which we are. My humble submission is there is no scope for passing any interference in the policy, or Lord, giving any writ of mandate.
Or the exercise which has been made by the authority while finding out the eligibility.
Exercise, your lordship can direct the authority to do a re-exercise. There is no issue on that, because I'm not saying the court has no power to do that. I'm saying not only a question of policy. On the policy, the court cannot enter into that arena because of the fact that this is a policy which is in consonance with Article 14 and 16. That submission I have made, Lord, based on the judge. So these are my submissions. If your lordship feels that's another question, but Lord, we have done our exercise and we have placed it before the court. We have found none of them are eligible.
Yes.
Right.
Short notes, if it is possible.
Only on the point.
Whatever you have just concluded, that part,
only that.
You need not elaborate.
Only on the point.
Your concluding submission is to be
much.
Yes. No. Thursday, not one.
রিপ্লাই দিবে তো
Reply what Monday? এই দেখো তো Thursday কোনো 3টের সময় কোনো ম্যাটার ফিক্স আছে কিনা?
Can I get the next weekend?
Yes.
Can I get the next weekend?
Yes. Friday, Thursday to? हाँ. Record an order. 26th at 3 p.m. Or 3:30, very well, 3 p.m. If it is concluded by half an hour, then I will take regular matters. Mr. Joydeep Kaur, learned senior advocate representing Garden Ridge Shipbuilders and Engineers Limited.
Can I have my lord's kindly?
Yes, has concluded submission. Stop. List the matter under the same heading as 3 p.m. fixed matter for giving reply on behalf of the petitioners. কি বললাম দেখো ম্যাটার লিস্ট না 3 p.m. fixed matter on 26th June 2025. Yes. এটার একটা জিআরএসি যেটা ইয়ে করলো এটার একটা এরকম একটা ব্যাকশিট করে দেবে জাজমেন্টস জিআরএসি বলে করে এটা একসঙ্গে আমাকে পাঠাবো